Good morning, everybody. Happy Friday Eve. Welcome to TCF Live. My name is Dan Soul. Having just averted a slight pre-show disaster, we are up and running, and we will start our day in the St. Joseph County, Michigan Justice Closet. This is Judge Pattison.
It is 613 South Erie Street, Apartment G. Is that the right address?
No, I just moved.
All right, so where should we mail things to?
It is 1005 Elm Street, Three Rivers.
Okay. All right, well, you're here this morning for an arraignment, and I'm sure Mr. Boy, I got the hiccups all of a sudden.
What was that? Are you all right?
Yeah. I was coughing, and the next thing I know, I got the hiccups that are just driving me nuts. And I'm sure Mr. Stickley explained this whole process to you. It's my understanding you're going to go ahead and plead guilty to what you're charged with. Is that right?
Correct.
All right, so let's go ahead and read you the citation. The allegations are that on June 16, 2026, you were driving a motor vehicle on North River Road in the village of Constantine of St. Joseph County, Michigan, and at that time, your driving privileges were suspended, revoked, or denied. That's a misdemeanor. It carries up to 93 days in jail, up to a $500 fine, and 2 points. Do you understand that?
Yes.
How do you plead to this charge?
Guilty.
And did you sign an advice of rights?
Oh, yes.
Thank you. Can I have the one? Let's see, maybe the front one too. Church, thank you. All right, you read, understood, and signed the advice of rights and plea information that I'm holding up.
Yes.
You understand by pleading guilty, you're giving up all the rights on this document?
Yes.
Are you under the influence of any alcohol or controlled substance?
No, sir.
Suffering from any stress that's impairing your ability to make a sound decision?
No.
Anyone threaten you in any way or promise you anything to get you to plead guilty?
No.
You're pleading guilty of your own free will.
Yes.
Were you driving a motor vehicle on North River Road, as was described in the citation that I just read to you, at a time when your driving privileges were suspended, revoked, or denied?
Yes, sir.
I find that you provide the factual basis for the plea. The plea is offered voluntarily, knowingly, and understandingly. It's accepted. And I don't think you owe the court anything, so there is a $50 state minimum, crime victim right fee of $75, court costs of $100, fine of $100. That's a total of $325. Are you able to pay that today?
I can pay 75.
All right. Do you need to set up a plan, or should I just make it due a month from now?
We could do a month from now.
Okay. All right. So what I'll do is I'll put on here that it's due August 16, 2026. And if you don't pay and you don't call for an extension or to set up a plan, ultimately you'll end up with a bench warrant for your arrest. So make sure you don't forget about it, okay?
Oh, I won't.
All right, so you're all set for today. You might check in over there. I think they'll probably just mail this to you. But they might give it to you while you're here. If you want to follow the deputy back over, I'll give you this, then they'll let you know, okay?
Okay.
All right,
Thank you, Your Honor.
Yeah, thank you. Have a good day.
You as well.
Good morning once again, everybody. It is TCF Live on a Friday Eve, and I want to celebrate something. This is the first time, I believe, that we've actually made it through a Judge Pattison hearing without him ending the stream right in the middle of it. So golf clap for him, everybody. We actually made it through. Alrighty, let's do this. Let's stay in Michigan, but let's go over to the 44th District, Royal Oak, Magistrate Urich. See what's going on with him this morning.
02837. This is People versus Kellyanne Dungan. And what's your name?
I'm Jack Dungan, her son. So I was driving the car. That part.
So, Mr. Dungan, you were present earlier when the court explained the nature of an informal hearing. True?
Yeah, true.
So you understood the instruction that you must select from one of three options to protect your own life, correct?
Yes.
All right, Mr. Dungan, this is a simple no parking pass in system ticket. Indicates that on June 4 this year at 2:30 in the morning, 2015 Audi gray in color was parked on Cambridge Avenue near Henley, City of Berkeley, and it was parked in violation of Berkeley's infamous 2 a.m. to 5 a.m. parking pass ordinance. So
Correct.
you have three options. You can admit responsibility, you may admit and explain, or you can deny responsibility, and we will conduct the trial. What would you like the court to do for you?
I would like to admit and explain, please.
All right. So you're confirming to the court that on the date in question, you were operating a motor vehicle. Strike that. You did have a vehicle plated to you or a member of your household parked as described in violation of the parking pass ordinance, correct?
That is correct.
Okay. What would you like to tell the court?
I moved that week and I didn't know, I moved, I think I got my house, the keys the 31st, and I think that was like my first night there. And I didn't know we had a parking ordinance or a parking pass. And that's just what I didn't understand. So I had parked in the street because I didn't have room. So, but I understand going forward, so I won't be parking in the street, or I'll be getting a parking pass. So just all I wanted to explain.
All right. So are you a new Berkeley resident, so to speak?
Yes. Yes.
Okay. All right. Fair enough. The court appreciates your honesty. Officer Luca, what would you care to share?
Your Honor, I'd like to welcome gentlemen to the city of Berkeley, and now that he's aware, I'm good with in the ticket, please.
Okay. This one's going to be dismissed, Mr. Dungan. Berkeley has three famous tags. It is the We Care City. It is the no parking between 2 a.m. and 5 a.m. city. And there's a stop sign at just about every residential intersection. So
I realize that.
Just keep those things in mind. Enjoy your stay and good luck to you.
I appreciate it. Do you know where you get the parking pass at?
That would be a Berkeley City Hall issue. You can jump on their city website.
All right, appreciate it. Thank you guys.
Good luck.
Have a good day. Bye.
Officer Luca, it wasn't my intention to speak for you on that question. Sorry.
No, sir. You're good. Thank you.
All right, well, he queues up the next contestant. Thank you, Barbara, for your $5 super chat. Happy Friday Eve. Don't forget Sidebar tonight. Don't forget Sidebar indeed. Sidebar needs more viewers. Help us out. Join us tonight, 8 p.m. Eastern, 5 Pacific. Thank you again, Barbara.
Joanna Johnson?
Yes, I'm here.
Thank you, Ms. Johnson. Ms. Johnson, today's the date and time for your informal hearing. You were present in the array for these Zoom proceedings when the court explained the informal hearing process. True?
No, I was not present for the first informal hearing.
Okay, so Ms. Johnson, today's the date and time for your informal hearing. This is a civil proceeding. It is non-criminal. No one's going to jail today on their ticket. However, it's considered serious enough that Officer Luca issued the citation on the date in question. That date was April 27th of this year at 9:05 in the evening. You were operating a 2018 Alfa Romeo, red in color, on 11 Mile Road and near Buckingham. In the city of Berkeley, at that place and time, it was discovered that vehicle's plate had expired in January of 2025. So a little over a year and a half ago. You have three options through which to protect your rights. You may admit responsibility. The court will attach a fine between 0 and the maximum, and that will close the case. You can admit responsibility with an explanation that you believe mitigates your circumstances, Or your third option is to deny responsibility. That is your right and your privilege. If you do so, the court will swear the parties under oath and conduct your trial forthwith. So, do you wish to admit and explain, or deny responsibility as to expired plates?
Admit and explain.
Very well. So confirming to the court that on the date in question, you were operating a motor vehicle in the city of Berkeley with an expired tag, correct?
Yes.
Thank you. Do you have the ability to activate your camera so that you might display an updated registration?
I don't have the updated registration because the appointment is not until tomorrow.
Okay. Thank you for that, Ms. Johnson. And is there anything else you want to tell the court about this incident?
No, only thing is, I did explain to Officer Luca why I didn't have the tag. It's actually just really just on hard times right now. I couldn't afford insurance and tags.
Mm-hmm. Okay. Thank you, Ms. Johnson. Officer Luca, anything you wish to share?
Your Honor, just reiterating, I did verify last night. It's current. It's not up to date as you stated, so I have no further recommendation than that.
Very well. Ms. Johnson, the court's going to attach the absolute minimum state fee in this matter, which is $45. That is payable through the pay portal on the 44th District Court website, or you can walk cash, check, or charge into this court at 400 East 11 Mile Road, Monday through Friday between 8:30 and 4:30. That's marked due within 14 days. You take care of yourself. Good luck to you.
All right. Thank you so much.
Calling case number 26, B like Berkeley E 03172. This is People versus Joshua Dennis Janowski. Sorry, that's you, sir?
Yes, sir. Good morning.
All right. Good morning. Mr. Janowski, you were present earlier when the court explained the nature of an informal hearing. True?
True.
So you understood the court's instruction that you must select from one of three options to protect your rights, correct?
Correct.
Mr. Janowski, the citation before the court was issued June 20th of this year at 18 past 2 in the morning. You were operating a 2010 Chrysler 300 black in color on Woodward Avenue M1 at or near Catalpa in the city of Berkeley. At that place and time, you were cited for having a plate that had expired on your birthday a week before, so June 13th. You have three options. You can admit responsibility as to the status of the plate on the date in question. You can admit, explain, and display an updated registration, or you can deny responsibility and the court will commence your trial forthwith. What do you wish the court to do for you?
I would like to admit and then display the renewed.
Very well. So you confirm to the court that on the date in question, you were in fact operating a motor vehicle in the city of Berkeley with an expired tag, correct?
Correct.
Thank you. What do you got?
Would it be better for me to hold it up, or is there a chat I could put?
Well,
the file
maybe
in?
Officer Luca perhaps checked it. We don't know that yet.
Sorry about that. I had it on mute.
You're fine.
I am looking. I verified he is all set. I make a motion to dismiss, please.
All right. Happy birthday, Mr. Janowski.
Thank you very much.
You're a young guy. You're going to be driving for another 50 years. You know what to do.
Yes, sir.
Take care.
Thank you, guys.
And I think that was a clean sweep for you, Officer Luca.
All right. I was showing one more. If you don't have it, they're probably not there.
If you'll stand by, I'll see if we can check that and find out what happened to it for you. Just a moment.
No problem.
Alrighty, friends. Once again, TCF Live on a Friday Eve. Stay in Michigan. Let's go say good morning to Judge McNally.
He just had one of these. You didn't learn much. Were you in front of me on the other case?
Yes, sir.
I must have done a bad job.
Well, you did a great job, Judge. We've never seen you not do a great job.
I'll tell you what, I'm not amused that he's in here a year later with another one. I took that plea back on June the 9th of 25, and then he goes and gets another one on June 27 of 06. He better give some serious consideration to sobriety court, Mr. Schwartz, or he might not like what's going to happen. You follow me?
We'll do that.
So here's what I'm gonna do. I'm gonna let you talk to your lawyer about it. I'm gonna order a screening and assessment. I'm gonna put a question mark, sobriety court. Question mark. I'm gonna order that you not have any contact with prosecution witnesses, that you not leave the state without the consent of the court, that you not violate a law. You must appear in the court as directed. You do have to attend 12-step meetings at least 3 times per week. No alcohol, no marijuana, no illegal drugs. You're to be on a SoberLink device by the end of the day, okay? So when you're gonna come up to the courthouse, you're going to meet with probation, and they'll explain to you what you have to do, but I want you on that by the end of the day. End of the day. I think you need sobriety court. I would assume that I'm going to send you to jail if you are not in sobriety court, okay? I'm gonna put this sentencing date out 1 month. We'll need to have a longer period of time if that's his decision. Heather, give me a date, please, in the 3rd week of August.
Will put us,
I thought Saturday was
That-
given. I thought.
that's
we were
Judge
working.
Heston's day. Do you want to do August 20th? Or do you
That's-
want to do, we have.
No, that's
Trenton
fine.
on
August 20th is 8:30. Good with you, Mr. Schwartz?
I'm checking right now. That's fine, Your Honor.
Sir, you need to seek out my court officer. He's going to give you an AA verification. You have to go in person. Every time you go, you have to have the form signed. Every time you come to court, you have to bring the form with you. Do you understand that?
Yes, sir.
3 times a week. SoberLink end of the day. You need to give serious consideration. Yeah, I'm not amused by this.
Your Honor,
Good luck.
I've had lengthy conversations with him. I'm 37 plus years into that program. And my assistant was recruited to be a volunteer in the Royal Oak program as soon as she graduated from the sober court in Royal Oak. So we have some experience with this, and Mr. Eschenroeder and I have had some conversations since I met him.
Is he 24?
Yes, sir.
Not good. Okay? You didn't learn from the first one. My mistake. I won't make it again. Get into sobriety court. Good luck. Dan
will.
is
Thank
you,
Transport
sir.
Inc. Thanks, Mr. Schwartz. Good to see you. Dan is Transport Inc.
Thank you for your help.
Thank you. 648-762. And I have also 761A, B, and C. Good morning, Mr. Robinson.
Good morning, Your Honor. Paul Robinson, key number 39327, appearing on behalf of Danny's Transport.
All right, so what do we have here? What's he pleading to? It looks like he's pleading, your client is pleading on files A and B of 6-1, right?
That is correct.
Um,
And Your Honor, I will note that we could not find 6-2.
the 6-2 is the misdemeanor jacket that I have.
Right.
It's right here.
Oh.
So he needs to address that one. This is Trenton. Can you call in Trenton, John? So that is an unsafe or improper load. So I'm gonna go ahead.
Well, that's the one being dismissed. That's C. So
But there's 4 counts here.
Right. What we're missing is resolution of 62.
Right. But that's the only misdemeanor. The rest would be for civil infraction. Mr. Bologna, your name?
Anthony Bologna, good city Trenton.
I understand he's going to plead responsible on A, equipment flares, B, defective equipment. C, serious safety defect will be dismissed, but you didn't address the unsafe or improper load. That's 262.
Is that the separate file, Your Honor?
Yeah.
Yeah, I didn't see that one, so.
Well, see, you didn't have just the tickets though. They were all in here. You follow me?
I got you. I just have the,
That's okay. I just need to know what you want to do with that.
that one we can dismiss too.
You can write that right on here. Sadie, will you hand him that? So again, I'm going to take your pleas. First of all, on the misdemeanor counsel, does your client stay in mute, waive formal reading?
Yes.
I'll enter a not guilty plea, and then he's going to plead, your client is going to plead, you were authorized to enter that plea, right, to the charges of count 761A and count 2761B and then I'll dismiss 761C and 26T648762. Right?
That is correct, and I do have authority to plead responsible to the A and B charges on behalf of Daniel's transport.
All right, the first one, count one, serious safety, I'm sorry, just safety defect, responsible or not responsible.
Responsible.
Count two, defective equipment, responsible or not responsible.
Responsible.
Pleas are accepted, 235 on each file, paid by August the 16th. I'm dismissing file C, which is the serious safety defect, and I'm also dismissing the misdemeanor charge of unsafe load on motion to prosecutor. I'll give them till August 16th to pay 235 on each file. You're all set. Have a great day. Thank you. Thank you. Glover? People against Glover. Do I have Ashley Leanne Glover? Come on up here, ma'am. 254-514-382. Your name, ma'am?
Ashley Glover.
You're charged with a violation of probation. You have the right to a lawyer. I'll be happy to provide you with one at public expense. Would you like one? I'll give you a lawyer. You're going to go out in the hallway, and we'll set you up right now. Who has Potter? Who has Potter? Any of you guys have Potter?
Good morning, Your Honor. Attorney Paul Spaniolo here.
Okay, David Alexander Potter, 26B150392. I'm sorry, counsel, your appearance.
Not a problem. Nice seeing you, Judge McNally. Attorney Paul Spaniolo. My P number is 72366. I'm standing in for the attorney of record, Jeffrey T. McCarty, on behalf and with Mr. Potter via Zoom, who sits to my right.
Are you with his office or are you just standing in?
I'm of counsel.
Okay. So, any objection to that, Mr. Potter, to Mr. Spaniolo standing in for your lawyer of record?
No, sir.
Your name, sir?
David Alexander Potter.
So as I understand it, your client is going to plead guilty to the charge of operating while visibly impaired with the super drunk to be dismissed. True?
Yes.
Yes, Your Honor.
Is that what you want to do, Mr. Potter?
Yes, Your Honor.
If you plead guilty here to that charge, the possible penalties are up to $300 in fines, 93 days jail, 360 hours community service. Court costs are all those 4 points, license suspension or revocation in accordance with your record. And your vehicle could be or might have to be immobilized depending upon your record. Do you understand that?
I do.
You are presumed innocent. They have to prove you guilty beyond a reasonable doubt. You have the right to remain silent. You have the right to a trial. At a trial, you have the right to question their witnesses, to bring in your own, to use the subpoena powers of the court, to bring in those witnesses. If you plead guilty, you'll be giving up all those rights, and we are not going to have a trial of any kind. Do you understand that?
I do.
All right. Any questions before I ask you how you plead?
No, sir.
The charge operating while visibly impaired, how do you plead?
Guilty.
Were you operating a motor vehicle on Fortner, Gibraltar, and Brownstown, April 18 of 26 at 2:05 in the morning?
I was.
Can you just keep your voice up a little bit for me? Prior to driving, you're fine. Prior to operating that vehicle, did you consume any alcohol? And if so, what did you consume and how much?
Yes, I did. I had 6, maybe 7 vodka Red Bulls and some beer.
All right. Was your ability to operate that motor vehicle impaired due to the consumption of the alcohol?
Yes.
In what way?
Why
were you pulled over by the police?
I was sleeping at a red light.
You think you fell asleep at the red light, at least in part because of your alcohol consumption?
Yes.
Car was running, correct?
Correct.
You were arrested, transported to the police station. Were you administered a breathalyzer at the police station, or was this a blood test?
We did a breathalyzer on the side of the road, then a blood test later on.
In counsel, were the results of the blood draw 0.171, and you stipulate that that was an accurate reading for purposes of the plea?
That is correct and so stipulated, Your Honor.
Are you on probation or parole right now, sir?
Yes, I think so for this.
No.
No, I'm not. Then no.
Have you been charged with any other criminal offense in your life?
No.
So you're not on probation for any case right now, right?
No, I misspoke.
Anybody force you to plead guilty or promise you anything to induce you to plead guilty?
No.
I'm going to accept your guilty plea. I find it to be an accurate plea made voluntarily and understandingly. Plea is accepted, operating while impaired. The super drunk is dismissed. I'm referring you for a screening and assessment. You are 20.
7.
All right. All right, $1,000 personal bond. You cannot leave the state without the consent of the court. You cannot violate any law or ordinance. You must appear in court as directed. No alcohol, no marijuana, no illegal drugs. I do want you to go into AA at least twice a week. So counsel, will you hand him a form? If you don't have one, we can send you one. You have to go in person twice a week until sentencing. We'll see how you're progressing. And every time you go, you have to have the form signed. And when you come to court, you have to bring the form with you. You have to come up here and be screened and assessed today. And we'll give you a sentencing date, Mr. Spagnola, that's good for you and your client and Mr. McCarty. So what do you have for me?
July 30th at 8:30.
Good with you, Mr. Spagnola?
That is, Judge, that's a sentencing date, July 30th.
July 30th.
And what time, Madam Clerk?
Yes.
8:30.
8:30, yes. And would that be in Zoom or in person, Your Honor?
As long as you're together, I'm fine with you doing Zoom.
Thank you. We appreciate that.
Okay, otherwise you both have to be here, okay?
With
All
respect to the AA sign-in sheet, Judge, can Mr. Potter pick that up at the court today? Or
Yes, he can pick it up when he comes here for the screening. Seek my court officer here, okay? Officer
great.
City.
Thank you.
Have a good day. Good luck, sir. People
Thanks.
against Pruitt.
Thanks.
Brett Lee Pruitt. 26G825 88A B C 26G825
679 on behalf of Brett Truth.
Sir, your name? All right. So Sadie. I've been meaning to tell you.
Okay.
All right. We're just gonna adjourn this again. How's he coming along?
It's coming along well, Your Honor. He has taken care of some of the issues. He has a roof on his house. He has siding on his house. He's working on cleaning up his yard. We're having a structural engineer come out and look at the boat hoist to prove that it's not falling down.
Good.
Wondering,
How long do we need here? A month?
month would be great.
Adjourn a month, Heather.
We could do August 27th at 9 o'clock.
Okay, so sir, I'm gonna expect everything to be taken care of then, okay? Otherwise, I have to set it for trial, all right? So August 27th at 9 o'clock. Thank you very much. Anything else, Mr. Lechner?
No, sir. Thank you.
Sir, you can go down the hall. We'll give you a paper notice, August 27th at 9 o'clock. Thank you. Cobb. Dale L. and Cobb. Which one do you have, Mr. Find out which. Come on up here, counselor. Tell her what you have, will you please? Dale L. and Cobb, 260-648-011. Your name?
Dale Allen Cobb.
I don't think I could take open in tax under 779. Have a seat 1 second. Have a seat 1 second. Sofia Elizabeth Panconi, 26G306865. Loitering. She's gonna stay out of trouble though, right?
Absolutely right. And good morning, Your Honor. Todd Lanta appearing on behalf of Sofia Panconi.
Ma'am, your name?
Sofia Panconi.
All right, your good lawyer got a good deal here. What was the allegations? What was she doing allegedly?
There was allegedly a little bit of a Donnybrook, Your Honor, at a residence, her residence.
Little bit of a Donnybrook. I like the way you put that. Okay.
But what I can tell you, Your Honor, her and her ex-boyfriend do not live together anymore. I am quite confident there will not be any issues, and that was the issue, Your Honor.
Do I have an appearance from you? Yes.
There is, Your Honor.
What the substitute in for Mr. Haas?
I filed my appearance afterwards. She never retained Mr. Haas, so she was confused that he had even filed an appearance.
Did you talk to Mr. Haas?
No, she didn't either. She talked to somebody who works with Mr. Haas from her job. And she told me she never spoke with Mr. Haas, never paid him any money, didn't know that he filed an appearance. She retained me. I showed up, filed my appearance, and there was
He actually filed a
motion to adjourn, I believe.
not only that, he's got a adjournment of the pretrial. We're here with Mr. Baloney. So I just want to make sure, Heather, you don't want him to represent you, right?
No, sir.
I'll just make a note. Charles Haas, not attorney of record.
Yeah, as of July 2nd, we have Mr. Landcott in here as the attorney.
Mr. Haas should have filed a motion to withdraw or stip an order to withdraw, but you don't want him to represent you. So I'm gonna find, Mr. Haas released. Just so there's no question, released from attorney-client relationship with her on this case, okay?
Thank you.
All right, so she's gonna plead to loitering, right?
Yes, sir. She's going to be responsible for loitering.
Is that what you want to do, ma'am? That's a civil infraction.
Yes, sir.
So that charge of loitering, responsible or not responsible?
Responsible.
Plea is accepted, 150 is your total, you're all set, go down the hall and take care of that. Good to see you
Thank
as
you.
always.
Great to see you.
And, take care of yourself. Thank you. Diller, I'm sorry. Dallas, James Jeffrey Goins, 26G307145. Your name?
Dallas going.
All right, you're going to plead to impeding traffic, true?
Yes, Your Honor.
Responsible or not responsible to that?
Responsible.
All right, I'm gonna dismiss the speeding. You're all set, 150.
Thank you.
You can go down the hall and take care of that. Good luck.
Can I set up a payment plan?
How much do you have today?
I get paid tomorrow.
When can you pay this?
Make a payment tomorrow and I just pay it like within a month,
How much can you pay tomorrow?
like at least 50, you can go.
All right, I'll tell you what. $50 due by July 17th. Then 50 bi-weekly until paid in full. Can you do that?
Yes, Your Honor.
So you're gonna pay again on July 31 and then August 14th, and that'll take care of it, okay? Good luck. Thank you. People Against Krupa, Michael John Krupa, 263-07142. Good morning, sir. Your name?
Michael Krupa.
Mr. Krupa, you're going to plead to impeding. You're speeding in a school zone. What are you doing? 53 and a 25, 7:42 in the morning on June 8th. Was school open?
Yes, it was.
What are you doing?
I was going to work.
Yeah, I know, but you're 53 and a 25. You hit a kid, you'll never forgive yourself, will you?
No.
Come on. Come on. Charge, they're offering the impeding still to that charge, responsible or not responsible.
Responsible.
I'll do that. You can hit you more in the pocketbook. You cannot do that. 85. Have a good day. Go down the hall, take care of it. Good luck. John Gurgley. John
Judge,
Richard Gurgley.
Judge, I'm sorry, you cut out. Did you say 185 for him?
I did.
Okay, thank you.
Thank you. John Gurgley here? Where's Mr. Gurgley? Is Mr. Gurgley here?
Well, I spoke to him earlier, and I've been looking in the hallways with him. I have a feeling he went maybe to the back of the police department to talk to somebody and he'll come back. That's just a feeling. So I would ask the court to pass him back.
Okay, no problem. I'll pass that. You think he went to the police department? This is a property maintenance case.
Yeah, I know. I went over it with him.
I get it. You don't have to explain. Davante Cargill. Davante Demon Aaron Cargill, 260-647-576.
Eating slop on behalf of Mr. Cargill.
How you doing, Mr. Cargill? I'd like him to execute this advice of rights. John, would you hand that to him, please? He's gonna plead to no ops, right?
Correct.
Is that what you want to do, sir? Take a moment, read that, stay right there, take your time, make sure you understand your rights. If you do, you sign it, and I'll cover this, okay? Heather, I'm pretty sure since open intox is on the traffic code, that we cannot take that under 771.1 on another case. Would you please double check that for me before I start telling people I can't do it, but I'm 98% sure I can't do it.
Okay, let me check, Judge.
Talking about me again.
I am. Boy, I got up and I thought it was gonna start raining. Just that. Huh? Smoke, my God.
I was up early. The sun was deep red.
Did you take your time? You understand?
I can't explain it.
Okay, good enough.
Sorry, I didn't.
It's all right. Mr. Cargill, if you plead guilty to no valid ops, I'm going to dismiss the suspend. The possible penalties are up to 100 fines, 90 days jail. Costs are all those. Do you understand that?
Yes, sir.
Did you sign, read, and understand the advice of rights?
Yes, sir.
If you plead guilty, you'll be giving up all those rights, and we're not going to have a hearing or a trial. Do you understand that?
Yes, sir.
All right. You understand everything?
Yes, sir.
To the charge, no valid operator's license on person. How do you plead?
Yes, sir.
Were you operating a motor vehicle on Grange near Marguerite and Trenton, January 21 of 26 at 2:02 p.m.?
Yes.
Do you have a valid license on your person?
No.
Are you on probation or parole? Anybody force you to plead guilty?
No, sir.
Please accepted, suspends dismissed, I'm ready for sentence.
Yes.
Is he in the process of taking care of all these other courts?
He is in compliance, substantial compliance. He still has 2 tickets left at 36, and he has appointments to take care of.
Use of today, huh? You gotta take, you can't,
They didn't take me care of it.
where do you work at?
KLS in Rollins, Michigan.
What do you do?
I'm a loader. I drop 4 cases.
And he showed me the check that he has coming in tomorrow. It should be enough to go take care
You're
of.
still suspended. You gotta go take care of your tickets. I'm gonna assume you're going to do that tomorrow.
Tomorrow I'm going today. If I can pay online, I'm going to pay tonight at 1 a.m.
What, you gonna be up at 1 o'clock in the morning?
$1% positive.
You're gonna be up at 1 o'clock? Why are you gonna be up at 1 o'clock? Nothing good happens at 1 o'clock unless you're working or,
My fiance, when she get out of school, she come straight home, so it'd be hard work. She work at NRB Trinity Health Hospital.
who's she?
My fiance.
Okay. All right.
It was my theory
So you gotta
that,
wait up for your fiance. All right.
it was my theory he was gonna be bringing serious books until it got tired and went to bed.
Anything else, Mr. Cargill?
No, sir.
Anything else, counsel?
No, Judge.
If he doesn't have a valid license, I can't go too late here. 100 fines, 100 costs, 75 victims' rights, $50 justice assessment, 3 1/4 or 60 days. Can you pay that today or do you need time?
Tomorrow I'll pay all those.
You sure? July,
Can I get 30 days?
I'll give you until the 20, I'll give you till the 31st, but make sure you pay it. Okay?
Thank you, Judge.
Good luck. If you need more time somehow, call the court. We'll go on Zoom. I'll give you an extension. Thank you.
Good morning once again, everybody. My name is Dan. It is TCF Live on a Friday Eve. It is good to have you all here. Some new friends out there. Good morning to you. If you have not yet said good morning to us, please take a moment and do so in the chat. We're friendly folk here. Pretty harmless for the most part, at least. Let's go down to Florida. Wade Mercer.
Ms. Miller, good morning. Ms. Miller, you're here because you're accused of violating the terms of your state probation. Ma'am, I've got a copy of the warrant in front of me, and it has no bond on it. What that means is I'm going to go ahead and arraign you this morning, and I want to get you a lawyer appointed if you would like to have one appointed. And then we'll give you some more information, see if you have any questions when I get through with that. Would you like to have an attorney appointed to represent you, ma'am?
Yes.
Okay, listen to Mr. McDaniel, please.
Your Honor, I spoke to Ms. Miller. She's going to plead not guilty. We're going to have to sit this in the August 6th court docket, and I advise her that an attorney from the PD's office will come by and talk to her prior to that hearing.
Thank you. I don't know that I actually said it, but I am appointing the public defender's office to represent you. That'll be your court date. The attorney will see you before your court date. Mr. Mitchell, anything?
No, Your Honor.
Mr. Miller, do you have any questions?
No, sir.
Have a good day, ma'am. Germaine Thompson. Lieutenant, I'm gonna need some help on Mr. Thompson.
Please.
So Lieutenant, there's a note from a sergeant at the jail. I see the teletype saying they want him, but the note says they've not been able to confirm with FHP that he has a fugitive from justice out of Wayne County. So I'm not sure what FHP has to do with it. Once you have the teletype, I thought FHP was out of it.
Right. Well, normally they would do a fugitive from justice complaint for us.
A
and that's why I
complaint.
had to do that report. because we didn't
They're
have it.
talking about a complaint. Okay, that makes sense what she's talking about. I don't know if that's required by law. I think that's the normal practice. But Mr. Thompson, you're here because you're allegedly wanted, it appears you're wanted out of Wayne County, Georgia. I know that you've had a chance to talk to Mr. McDaniel about the waiver of extradition process. Do you have any questions about that process?
No, sir.
Okay, and do you want to waive extradition to go to that county and address this issue, or do you want to contest it? waive it. All right, so you've got a waiver of rights form there. If you want to sign that, please, Mr. McDaniel, are you satisfied he's doing this freely and voluntarily?
Yes, Your Honor.
Thank you.
Sure.
Mr. Thompson, I'll see you in 15 days if you're still here. There's a good chance you'll already be gone, but if you're still here, I'll see you. They have 30 days to pick you up, but I'll see you in 15 days. That's just the way I prefer to do it, just to keep a track on everything. If you're still here, you come back to first appearance. I'll ask the first appearance officer what the issue is with the transport. What have they been told by Georgia? You'll hear that. If you're still here on 30 days, on the 31st day, you're released. Any questions?
No, sir.
Have a good day, sir. We have Eli Simpson next. Mr. Simpson, good morning. Mr. Simpson, you're here because you've been accused of one count of driving under the influence. There is probable cause for the charge. I'm appointing the public defender's office to represent you. I'm going to ask that you listen to Mr. McDaniel, your attorney.
Your Honor, I've talked to Mr. Simpson. He's going to plead no contest to the charges listed. If adjudicated guilty, 11 months, 29 days probation, $1,078 in fines, 50 hours of community service, DUI school, AA counseling unless he gets signed up within the first 60 days with his DUI school. Then he can satisfy that requirement by completing the DUI school.
Thank you. Mr. Mitchell's at agreeable with the state.
It is, Your Honor.
Thank you. Mr. Simpson, did you hear that agreement?
Yes, sir.
Do you have any questions about that agreement?
Yes, sir.
And is that the plea you would like to enter?
Yes, sir.
All right, Mr. Simpson, I'm going to accept your plea of no contest to the charge of driving under the influence. I'm going to judge you guilty of that offense. This was a regular DUI plea.
Yes.
Sentence you to 11 months and 29 days probation, court costs and fines of $1,078. Successfully complete substance abuse counseling, 50 hours of public service work, 50 hours of, excuse me, I already said that, DUI school. I do recommend the minimum driver's license suspension. If you enroll in the DUI school within 60 days, that will constitute your counseling. Otherwise, you've got to do at least 12 AA classes or another approved program. Mr. Simpson, what's going to happen next is they're going to let you use the phone at the jail to set up transportation. Then they're going to bring you to the courthouse because the courthouse is where the probation office is at. So when you get here, if you use the phone, tell your friends or family, whoever you call, if you call somebody for transportation to pick you up at the courthouse in roughly 30 to 45 minutes, you should be ready to go by that time. Mr. Simpson, do you have any questions?
No, sir.
Have a good day, sir. Thank you. Willie Smith. Sir. Mr. Smith, good morning. You're here on a 7-day holdout of Calhoun County. Looks like you had a local charge. You got set a bond by myself or another judge, and there now is a warrant out of Calhoun County. I'm looking at a copy of it now. Judge Young has signed a no bond warrant for violation of probation. So if you post bond here, you'll then go to Calhoun County and deal with that. If you don't post bond here, you'll deal with, if you post bond, you'll go to Calhoun County now. If you don't post bond, you'll deal with our charge first and then go to Calhoun County later. I don't know if I gave him a court date previously or not, but it would be August the 4th, correct?
Yes.
So if I didn't give you a court date in Jackson County or earlier, it'll be August the 4th will be your court date. Do you have any questions, sir?
No, sir.
All right, sir. I wish you the best. Michael Robinson. Mr. Robinson, good morning. Mr. Robinson, you're here for the charge of violation of county probation in 23-224 MM. Good morning. You also have those other two holds I told you about the day before yesterday. Those are Sarasota County and Orange County. Mr. Robinson, in the Jackson County violation of probation charge, I think I waited a couple of days to give the probation office time to look at the documentation you provided and also give the state time to look into it further. Listen to Mr. McDaniel. We'll kind of see where we stand this morning.
Your Honor, I spoke to Mr. Robinson. He's going to admit that he violated his probation. Understanding he's going to be sentenced to 60 days in the county jail, 4 days jail credit, any remaining fines that might be owed to the case.
Mr. Mitchell's at agreeable with the state.
It is, Your Honor, and I haven't heard anything back from Sarasota or Orange County yet, but I'll keep at it.
I was nothing to hear back from him.
When would you hear back from him?
Yes.
I apologize. I'm confusing him with another defendant right there.
As far as remaining court costs and fines, $170 is what he's got left. Mr. Robinson, did you hear all that, sir?
Yes, sir, but I guess I have a question.
Okay, go ahead.
You guys were saying that you reviewed everything. I have my AA meeting slip here that has all the dates and stuff on it.
And Mr. Robinson, I told you, we got that and they've all seen it. They understand that.
Yeah, I saw that. Probation office did show me that. I also saw your notes where you supposedly told them that you had quit. February 20th, you supposedly quit going to counsel and got frustrated. And I've seen the notes from the judicial assistant where someone claiming to be you called and was told about this warrant in 2024 and never dealt with it. So you certainly have the right to a VOP hearing. You have the right to a VOP hearing, or you have the right to plea. It's entirely up to you. If you want a VOP hearing, we'll schedule that today. If you want to take the plea offer, that's okay too. But what I've seen so far, I think this is a reasonable and fair resolution to the case, especially considering all the factors that I'm aware of, which is not everything. Obviously, there's things I don't know. With the limited amount of information I have, this is a fair resolution from my perspective. If you admit, if you don't want to admit, that's perfectly okay. We'll schedule you for a VOP hearing, Mr. Robinson.
No, I do admit, I was just.
Nothing else. Thank you, Mr. Robinson.
Okay, Mr. Robinson, I'm sorry, go ahead. I couldn't hear you. Say again.
I just don't know what. I got a lot of stuff I want to talk, and they telling me not to say nothing.
Okay, we'll schedule you for a VOP hearing then, and that way we can let you decide.
I'll take the time, sir.
It's entirely up to you. I don't want you to feel pressured. I didn't put you in this situation. You've got warrants in 3 different counties in the state of Florida. You're going to be sentenced to jail time if the state proves its allegation against you. They haven't proven it. You're accused at this point. So I'll schedule you for a hearing, or you can take the offer. It's entirely up to you.
I'll take the offer, sir.
All right. I'm going to accept your admission that you violated the terms of your probation. I'm going to sentence you to 60 days in jail, give you credit for 4 days you've already served. You still owe $170 on your court costs and fines. You have holds from 2 counties in Florida. I went over the bonds on those. I remember one of them was no bond. What about the second one?
No bond.
But no bond in both counties. When you get near the completion of your sentence, when you get down to around a week or so, the jail's going to go ahead and contact them, Sarasota County and Orange County, and say, he's through with our charges here. Come and get him, please. So you may actually do the last part of your sentence in one of those counties. I cannot tell you which county you'll go to first. I have no idea, but I know both counties say they want you for 2 different, totally unrelated matters. Do you have any questions?
Yes, sir. If Sarasota County drops the charges, what will happen?
If they send something saying in writing, it's got to be in writing, to our jail saying they no longer want you, then our jail would drop that hold immediately, and then you've only got to deal with Orange County. Okay?
I don't know.
Any other questions?
It's the manager at Lynn.
I've talked to you about this now. I mean, there's nothing to talk about, sir.
All right. I just have anxiety. I'm sorry. All
right, Mr. Robinson.
Our clerk has a question. Yes, ma'am.
4 days credit or 6 days?
6 days credit.
I'm sorry, I wrote down 4. So I made a mistake. I wrote down 4. It's actually 6 days credit, not 4 days credit. Mr. Robinson, I wish you the best.
Thank you, sir.
Yes, sir.
They caught that chair on.
So, Lieutenant, that's everything I had on my list. Anything else from the jail this morning?
No, sir, that's all we got.
Thank you. Mr. Mitchell, anything from the state?
Nothing from the state.
Thank you. Mr. McDaniel?
Nothing.
Alrighty, friends. TCF Live on a Thursday. Still in hour 1. It feels like we've been doing this longer than about 50 minutes. I don't know. Normally time flies, though, so it's weird. But whatever. It's good to have you all here. That's what matters. Let's go back to Michigan. Judge Oakley.
Ms. Cook, I'm standing in for Mr. Amadeo. Counsel is corrected. Ms. Cook said my left was strictly to the shall
Thank you. That's all right for you, with you if he stands in? Okay. Counsel, did you have a chance to go over the report and recommendation?
Yes, Your Honor, we don't have any additional correction conditions.
Okay.
Yes, I we would ask that the court follow the recommendation.
Okay. Ms. Cook, anything you want to add? You don't have to. I just want to give you a chance.
No, just that I'm in continue and also already part of a volunteer organization.
Good. Good.
And that needs to be provided to go on the deal.
What's the volunteer organization?
It is on the Humane Society of Grand Valley.
Yep.
Animal shelter.
Yep. Okay. All right. So you saw the recommendation. I'm gonna order some community service. You can do it there or any other nonprofit, as long as it's registered with the IRS. Official letterhead from the nonprofit that shows you've done X number of hours, and those X's total 40. All right.
Anything else? Right. Before you took the, when you did the pre-sentence investigation, part of what you did was the adverse childhood experiences survey.
Sure.
Have you ever heard of that before?
I mean, I completed it. I didn't know if that was.
Yeah.
what it's called.
I'm gonna tell you for your own benefit, do a deep dive into ACEs. That's what they call those ACEs, adverse childhood events. It's all about childhood trauma and how the trauma can affect your life forever. You scored a 6. That's fairly high. I'm going to suggest you do a deep dive into the research and what it shows, and I think you're going to come up with a better understanding of how you do, why you do what you do. Okay?
I think that's my therapist, my psychiatrist.
I can guarantee you they're well aware of ACEs. Okay? All right. So I'm going to go along with the recommendation, no probation. We're just going to do fines and costs in the 40 hours. Total on the fines and costs is $1,300. Before you leave the building, I either want you to pay it or have a plan in place to get it paid. Questions?
No questions at all. Thank you.
You're all set.
Thank you.
Oh, the community service has to be completed by November 1.
Okay,
Yep.
Thank you.
Thank you.
Have a great day, people. Council, what do you got? Last name is? Delecta. Come on up. First name Todd.
Oh.
Good morning, gentlemen. And did you fellas have a chance to look at the report and recommendation?
We have had a chance, Your Honor.
Any corrections?
No, just request for a slight modification.
Tell me.
Sure, Your Honor, I have known Mr. Delecta for many years. He works as an iron worker. He's worked as an iron worker for 25 years.
Okay.
3 children, 19 is his youngest. He is married. From my personal knowledge of him, he is a very much a solid individual. He's a trustworthy individual. He does understand the screw up basically.
Yeah.
And he understands the gravity of it. But what we are requesting is because of his work schedule, he does work a lot. If the court will consider waiving the community service provision in that recommendation.
What's your work schedule?
6 days a week.
And do you work one location or are you moving all around? Yeah. Yeah. Where are you working now? Okay. Well, that's close to home. Okay. Okay. All right. What I'll do is I'll let him, just so you know, work program is an alternative to jail. All right. I've had very few people choose that option. But what I'll do is I'll give you a third option, which is community service hours. The charity work that I just talked to the lady about in front of you gives you a lot more flexibility. The work program requires you to pick 4 days and then show up the day you're scheduled. The community service gives you the option of just getting it all hooked up, and you can do an hour here, 2 hours there. You know, you get rained out on a job, you can go show up and do some hours. So I'll give you that option. So instead of the 4 days, I'm going to order 32 hours. Community service. And as I told the lady in front of you, that's any nonprofit registered with the IRS. Let's see. Get that done between now and September 1. Doable?
We'll take, but I'll make it work.
I'll tell you what, if you come to me and want more time and you've done none of it, I'm going to tell you no. If you come to us and say, look, I'm not going to get the last 10 hours done in the next week, so can I have some more time? We'll work with you. All right. So just don't put it off till last minute. All right. Other than that, I'm going to adopt in full the recommendations of the probation department. You're on probation for 9 months. Those recommendations that you went over with counsel, those are now all court ordered. Fines of cost, $1,300. Same thing I told the lady in front of you. Go downstairs and either pay it or make a plan to get it paid. Any questions? Good luck to you. Counsel, always a pleasure.
Thank you, Your Honor.
All right, friends. Well, he's between contestants. Let's move along. Let's go to Otsego County, where justice is best served in a converted pole barn. Judge Hunter. No, not Judge Hunter. Just that fast, he deleted his stream. What is wrong with these judges, I tell you? All right, never mind. Let's go back to Judge McNally.
Responsible to impeding traffic, right? You got a clean record, huh? Good for you. All right, to that charge, responsible or not responsible? Please accepted. Speed's dismissed. 150 is your total. You are all set. Good luck. Peggy Diane Neeson, 263-07-170. Your name? All right, you're going to plead to impeding traffic, right? You also have a clean record. Good. To that charge of impeding, responsible or not responsible? Please accepted. 150. You're all set. Speed's dismissed. Good luck. People against. Did you find that out? Where is Ms. Tremblay's here? Priority waste. Priority waste 26T 648-689. Good morning, Ms. Tremblay. I had your other sidekick in here yesterday on a different Tuesday, maybe. A different case. Mr. Dillon, I mean, former, you know.
Oh. I'm like, well, good. I'm just glad he's still active. Good morning, Your Honor. Elizabeth Tremblay appearing on behalf of Priority Waste.
So I've got 26T648. You got several of them here.
Three of them, yeah.
689A and B. So as I understand it, correct me if I'm wrong, they are going to dismiss file A, the safety defect. You are going to plead responsible on behalf of the company to misload with agreed upon fines and costs of $300. True?
True, Your Honor.
To the charge of misload, responsible or not responsible?
Responsible.
Please accepted. Fines cost $300, paid by August the 16th. And the serious safety defect is dismissed. All right. And I'm going to give you till August the 16th, if I think I said that.
Yes, Your Honor. Thank you.
And then let me call these others here and get you out of here. People against priority waste 260-648-750. Your appearance again?
Elizabeth Tremblay appearing on behalf of Priority Waste.
You're authorized under this plea to misload, correct?
Yes, Your Honor.
To the charge of misload with agreed upon fines and costs of $300. How do you plead? Responsible or not responsible on behalf of the company?
Responsible.
Please accepted. $300 paid by August the 16th. Priority waste. People against priority waste 260-648-799.
Elizabeth Tremblay appearing on behalf of Priority Waste.
Wow. Because it just goes on their track. Opening goes on the track.
Yeah, good. Yep.
Okay.
This is issue, but I would do something that basically says it's still going to go into but
Then we're ready.
we send it off to your abstract, it's equal to but it's on tape.
Right, I got it. Okay, thanks. I'm sorry. Priority waste 260-648-799 and B.
Elizabeth Tremblay appearing on behalf of Priority Waste.
All right, you're going to plead to overweight. They're going to dismiss the annual inspection. There's agreed upon fines and costs of $1,000. True?
Yes, Your Honor.
All right, to that charge of overweight, responsible or not responsible?
Responsible.
All right, fines cost $1,000, paid by August 16th of 26. And I'm going to go ahead and dismiss the annual inspection charge on their motion. Anything else?
That's it, Your Honor. Thank you so much.
You have a great day. Thank you.
You too. Thank you.
Glover. People against Ashley Leanne Glover, 2625R514382. Sir, I can't really do that for you, Mr. Cobb. I'm going to explain that wherever you are in a second. I'll explain it to you. We're going to call in Mr. Bologna after this case, John. All right, 25R 514-382, Ashley Leanne Glover. Your name, ma'am? Counsel?
James Schloff, 30720.
I have a charge here of failure to refrain from consuming alcohol, testing positive for alcohol on a chemical test on June the 15th, and a second count that alleges the same violation only on July the 14th. So two different violations here. If you plead guilty, ma'am, at any time, I want you to understand you could get 10 days. That would be two technical violations if you were to plead to both of these. Do you understand that?
Yes.
Counsel, how is she going to proceed?
Right, well, she will acknowledge that she's in violation.
All right, call in Beth for me if you would, Sadie. If you plead guilty here, ma'am, I want you to understand, again, you could get 10 days. Do you understand that?
I understand.
Did you sign, read, and understand the advice of rights?
Yes.
If you plead guilty, you'll be giving up all those rights. There will be no hearing or trial. Do you understand that?
Yes.
All right. So as to count one, that you failed to refrain from consuming alcohol, testing positive for alcohol on a chemical test on June 15 of 26, how do you plead?
Guilty.
Did you test positive on a chemical test at DNA on that date?
Huh?
Did you test positive?
Yes, at the DNA Diagnostic Center.
Correct. And had you consumed alcohol, say within the 3 days preceding that date of that test?
Yes.
Is to count two, to the charge that you failed to refrain from consuming alcohol, testing positive on a chemical test on July 14 of 26, how do you plead?
Guilty.
Did you test positive on that chemical test on July 14th?
Yes.
And had you consumed alcohol, say within the 3 days preceding that?
Yes.
Anybody forced you to plead guilty?
No.
All right, I'm gonna accept your plea to count one, accept your plea to count two, testing positive, count one, June 15, 26, count two, July 13, I'm sorry, July 14th of 26, my apology. Please are accepted to both. So what are we doing here? Ms. Wild, your name? I just placed her on probation on December 11 of 25, which isn't bad. She hasn't had any priors, but all of a sudden she's drinking a lot. What's going on, Mr. Schloff?
I will state this to the court. I was not the original attorney. I did learn some of the circumstances from my client. I would state to the court that she has, as the court has already said, no prior criminal history. And she has done pretty well on probation up until recently. I presume that she reported and has taken care of all the other circumstances on probation. I discussed with her, considering these violations and involvement with alcohol, that she consider starting a 12-step program. I'm surprised that no one has talked to her about this before. I think it's an important way to avoid these type of situations. And it should be a lifetime commitment. This could be a good tip off for her. She has a job, Your Honor. She has 3 children.
Yes.
3 children that she takes care of. And she's going to school. She has one online degree, and she's working on another one. So I would ask the court to give her a stern warning on this, allow her to continue on probation, and make some type of recommendation, or I should say order for rehabilitation.
Ma'am, anything you would like to say?
No.
All right, just take a deep breath, relax. Ms. Wilds, what is happening here? Do you know?
Yes, Your Honor. So she has completed all her terms and conditions. We were actually essentially on the verge of quite possibly petitioning the court for early discharge. June 11th was her halfway point, and she had that first positive and the second positive. After the second positive, she did email. Even with the first one, she was pretty forthcoming as far as their use, not denying or kind of making up any lies or anything of that nature. She did indicate that after her second one, she emailed me and let me know that there's some family trauma, and is the reasoning at this time frame of this season, I'll say, that she drank. So to her credit on those things. However, again, with the alcohol consumption, I don't disagree with counsel. I don't think 12-step meetings are appropriate. I think treatment. She needed to deal with the reason she's indicating that she resumed drinking at this point in time. So I don't disagree with her continuing probation until December. My recommendation would be court work program, as well as for herself to get into some substance abuse counseling.
You have you have the opportunity to keep this conviction off your record. You know that, right? But you gotta comply. I'll keep you on probation subject to all existing terms. Pay additional costs of $75, serve 8 hours of community service by August 15th. I'm gonna just consider this to be a bump in the road, but
I know.
you're to test bi-weekly throughout the duration of probation. You're to attend AA twice per week until you're in an outpatient treatment program. Once you get in outpatient, you no longer have to attend AA or NA, okay? So twice a week until an outpatient. We'll give you a form. Once you get in outpatient, you no longer have to attend AA or NA. And then you'll do that until you're completed with it, okay? All right. I'm giving you, did I tell you the date? Community services due is by August. I think I wrote down the 15th. Yes, 15th. Okay.
How many hours or?
8 hours.
8 hours.
I wish you well. Good luck. Can you pay the 75 now or do you need time? So you pay that now and you talk to her. Go from there. Real quick, call in Mr. Bologna, please.
Okay.
Alrighty, friends, let's get out of Michigan for a little bit. Go down to Texas, Judge Stevens.
That's just defense copy.
Oh, funny.
You're gonna make me mad in a minute, and then we're gonna have a little discussion about it. This is not
Patience.
something.
Hey, what are you going to do?
Where's the defense copy? This is.
They always in the bedroom. I don't know if it was in the.
Maybe that's why I thought that.
How much? I get that.
You say you,
Does he not?
somebody have it for 40 years?
Huh? No, I took this kids.
I'm not. I get it. I'm not. Okay.
Okay, here's what, we have clause number 24 CR 565, the state of Texas versus Jonathan Cruz.
Yes, sir.
And your attorney is Mr. LeBlanc and the state's attorney is here. You're charged with this state jail felony.
June 16th.
And it is included with the indictment or allegations of 2 prior convictions. In unlawful delivery of a controlled substance in 2005 and attempted assault, family violence in 2012. Those are state jail felonies. If you were convicted of this state jail felony and these 2 state jail felony prior convictions in paragraphs 2 and 3 were proven true, you were looking at a state jail felony punished as though it were a 3rd-degree felony. Correct, everybody?
That's correct.
So you're looking at no less than 2 nor more than 10 years confinement in prison and a fine up to $10,000 can be assessed. Do you understand all of that?
Yes. Yes, sir.
All right. Everybody has some time to think. Where are we headed?
Judge, we came here yesterday, we had a plea. Or she's offered state jail time, so she's got enough time to go. This case, I think I was advising that.
For a state jail.
Yes,
That's what,
he could still go to
but
trial.
it could be
Yes, Judge.
punished up to 10 years in prison if he doesn't take the deal.
Correct.
That's correct, Judge.
And
What's he gonna
here
do?
he's offered a time served. She's offered a lesser included the first count for state jail.
How much time does he have credited?
800 something.
Maybe 842 days now.
What's 2 years worth? What's 2 years? 730.
Yeah, yes. And definitely, I had this year's first. And so, but we're ready for trial. It's just that.
How many days does he have?
I'm triple checking, Judge.
At the end of the day, it's his free will. It's his voice, you know. He gets to
decide what direction it goes in. I mean, we're just go with it's his life.
842 days. So if he has credit for time served, if it's a state jail, we can release him from the county jail today.
It's got over 100 days more. So what are we doing? We're gonna go to trial?
No, Judge, yes, I guess so, but we had a plea set up, and we want to talk to the court because he's done his own research, and he thinks that he should be sued civilly before criminal, because it's a theft of.
That's not a debate you and I are gonna have. That's not a debate you and I are gonna have. I am presiding over a criminal charge that has been handed up by the grand jury. This isn't going to go into a debate between you and me as though it should be civil or not. The prosecutor takes care of what prosecution direction it goes in. He defends you, and I'm the arbitrator of the charging instrument. So I'm not going to debate. I'm not going to talk about whether it should be civil. This is a criminal court, and it's been handed up by the grand jury. Not her, they asked for it, but the grand jury makes the choice, and then I respond by two things: either disposing of it by allowing the parties to agree to a disposition, or like yesterday, we had another 615th jury trial here, 615. And they disposed, the jury found guilty and sentenced. And that's what happens. We try cases. But it's this thing with a civil is not a debate with me. But as long as you are aware, they've offered you a plan of disposition where you can walk out today.
I still have a parole.
And well, that all I'm talking about is what is in this set of facts in this case. Now, if you don't want that, then what happens is it will defer, you'll set it on the trial docket, and you'll be looking at up to 10 years in prison. And that's your choice, though. Everybody up here makes a choice.
I was released from prison. I was the victim about anything. This one.
All right. We're just going to put it on the trial docket. It's not I told you it's not a debate. It's your choice, sir.
You said
you're not debating with me.
Debate, I'm speaking.
I'm making a ruling, sir.
Said that he's important. That he got my habit.
Once again, that has nothing to do with what the decisions I make, sir.
Hey, this man. I'm not looking for free representation.
Okay, then here's what you do. Go to trial.
It says
we'll set it for trial.
It says right here before I.
That is all.
It said before I go before criminal court, it's a civil court matter. It says right here. You won't let me read the law. It says on the. It says on the. You go have my list of documents. Yes, sir.
Did you send all that stuff to your lawyer?
Yes.
Okay, that's him. All right. He's handling it. He's going to handle it.
That I haven't done.
We're going to set it for trial. It'll be set for trial. Get ready for trial. And we'll let a jury decide what direction it should head in.
I didn't even, he brought that up.
All right. Some defendants really work real hard against themselves, but that's one of those cases that's the third or fourth time we've talked about the same subject matter, and he doesn't seem to want to listen, but he has a right under the Constitution for a jury trial. That's what we'll do. Okay, Joseph Babineau.
I won't put it back on the time.
Where is?
He's one around. I'm not, we're down. Yeah, I know.
Okay, 26 CR 419, Joseph Allen Babineau. You're charged with a third-degree felony of theft, right? Where are we going on this?
Well, Your Honor, I just today received discovery, and the media I still haven't received. There was an error when they were sending it out. They sent it to the wrong person. So I'm waiting for discovery before I can really tell you exactly where we're headed.
I needed to. Okay.
Well, what are we waiting on for discovery?
Media.
When is that gonna happen?
According to Mr. Laird, he's going to get with them today and have them resend it to me since it was sent incorrectly.
All right, so how long do you think that'll take? So we need to reset him for a certain, 2 weeks gonna be good?
No. 2 weeks is good for me. She should have it.
All right, reset 2 weeks because we're rolling along here and we need to move forward in a direction toward
We got
conclusion.
three. We got three just to be safe.
All right. Okay. Get a resetting there.
Right, thank you, Jeff.
Patrick Brochet,
How many are fresh wrong? Okay.
Kevin. There you go. 26 CR 321. Defendant is charged with a third-degree felony of deadly conduct, which means you were facing if convicted no less than 2, no more than 10 years confinement in prison, and a fine up to $10,000 can be assessed. We understand what you're facing. I know. And listen, it's time for an announcement. Which direction are we heading in on this?
Your Honor, we have received an offer of a cap of 6 in this. We have discussed that. I've seen the videos. I have the discovery, and we're asking for a jury trial at this time.
All right. That's what you want? No deals. It will be a jury trial. And
Well, Your Honor,
we will set that. No.
If the
No.
court is
This
no
we gotta
deals,
go- We got to go in a direction one way or the other.
then we'd like a 2-week reset if it's a no deal deal. Because I didn't explain that to him, that if the court doesn't take that now, that he's not able to plea.
Well, hold on. So this thing was.
And I'm sorry, that's my,
It's been 5 months. What do you?
I didn't know that the court was going to say no more.
That's what we do now. We're setting it for trial, and that's what we do. And we try. I mean, like I said, I just finished 615. That's what we do. You want trials, you get trials. But if you say I want a trial and that's not what the plan is, let me know, because we've got trials to try, and we don't need to be placing things on the trial docket that aren't really going to go to trial.
Yes, sir.
For instance, this mayor, y'all know what's the facts are. I don't, but the gamesmanship about putting it on trials, it's just stalling that the court's trying to stop. And so that, because most things that get on trial end up getting disposed of without a trial.
I understand.
And all it is we're kicking a can down the road, which is not getting things done. How much time did you say you wanted?
2 weeks, Sean.
Okay.
Thank you.
All right. Get a resetting. Maya Edwards.
Thank you. Yeah, I was on time.
She's discussing an offer right now.
Well, she needs to be in here because she's got the rest of the docket. Okay, I've got your 3 left,
Yes,
Reagan. I've got Edwards, Elam, and Percy. Who is this person?
Maya Edwards.
Okay.
And Judge, this is one that I was working on with Ms. Gasper. I just got an answer today with Mr. Laird about maybe the consideration for a different type of offer or a lesser offer. He has re-extended the same offer, but if I can just have 2 weeks to make sure that my client is making an informed decision about that offer or setting it for trial, we will know what that answer is.
She has an interlock device in any vehicle. Are you driving?
Not driving.
Did you drive up here? Who drove you up here? Okay, good deal. You can't operate a motor vehicle without an interlock device until this gets all finished, which means it's something you have to blow in, and it tests you to make sure that you're not intoxicated. But all persons charged with crimes involving vehicles and intoxication have to have that. If they don't drive a car, they don't need it.
Yeah.
But if you do, whether it's yours or anyone else's, there has to be an interlock device, which allows you to start the car only upon passing the test. So that's important. We don't want, worst thing would be something bad happens in a car when you're intoxicated and you didn't have it after you've been warned, then your bond would probably be revoked. And then you would sit it out in jail until we can get all this finished. That's, because vehicles can be dangerous and cause damage. How much time do you want?
Just 2 or 3 weeks, Judge.
3 good?
Yes, Judge.
Okay. Sad thing.
Just sign on the X for me, please, ma'am.
Mark Elon. This is you?
Yes, sir.
Okay. In 25 CR 1456, you were charged with the second-degree felony of aggravated assault with a deadly weapon, which, if convicted, as you probably know, you're looking at no less than 2 nor more than 20 years confinement in prison, and a fine up to $10,000 can also be assessed. Do you understand the punishment range here? All right. What are we doing next?
Judge, he wants to set his case on the trial docket.
Okay. This is fine. It will be set for trial. Have you talked to the victim on this at all? Because
I have not touched.
What's happening over and over again, victims are getting contacted.
I just, as you're well aware.
Contacted by defendants.
Yes, as you're well aware.
Making deals on the side.
I just inherited this case and I'll make an effort to reach out.
By rule, you can't contact the victim, nor anyone on your behalf contact them to try to influence the outcome of this case. Do you understand? All right.
Your Honor, I will say this. I've got 1, 2, 3, 4, 5 different witness statements giving an account of of what transpired, Judge.
Yeah, but at the end of the day, the victim's got to show up or it's hard to win. But I don't want to, as long as they're, there's no finagling going on behind the scenes.
Yes, sir.
Because it's happening over and over again. Here.
Cases we travel with all the time.
I don't see any prior convictions here.
That's correct, Judge. He would be eligible for probation for this.
He is probation eligible, Your Honor. However, I find it difficult to offer probation to a defendant with a 60-round drill magazine and an AK style firearm that was allegedly brandished, Judge.
You're still eligible for.
That's correct.
Probation.
I'm just not inclined to offer.
Okay. This will be set for trial as soon as we can get to it.
Thanks, Judge.
Then we go to Elisa Percy.
Judge, I had her mother in contact with me outside of the courtroom this morning. Elisa was rushed to the hospital this morning with a cyst that had bursted.
With a what?
A cyst on her ovary. So she's at the hospital. I'm waiting on documentation of that, but her mom was up here.
We need to get that.
I know, and she's working on getting me documentation for that. But her bonds people have also informed her and me that any drug patch issue that she had whenever she first put it on has since been resolved because those levels are going down. So any drug patch issues as well.
I don't know much about that, what you're talking about.
There was just a notation on my docket that there may be potential of drug patch issues, but it seems to have leveled out and is not an issue.
There's a positive test of methamphetamine and amphetamine back. It looks like May.
Right, so when they first get out on bond and it's
he admitted to the marijuana and then admitted to a THC, claims to be on Pattison. Oh, the bags.
Those issues have since resolved themselves, though. I was just informed that that's not.
That's what they how do you reserve?
So, once again, what do you want to do?
I would think at least a 4-week reset, Judge, just depending on how surgery goes for her and what that looks like. I'll have a check-in with the court as soon as I'm able to. It is an initial setting, so I have not had a setting with her before. So if you want to do 6 weeks to be on the safe side, I think we have room for that.
Can you get something
Yes, Judge, I'm working on it.
verifying within 2 weeks?
Yes.
Okay. Something.
All right, friends, we'll keep an eye on Judge Stevens' court, likely to be back later, but let's head slightly east over to Louisiana. Let's check in with the board this morning, see what they got going on.
Mr. Newman, you're before the Louisiana Committee on Parole this morning. To my left is Mr. Tillis, to my right is Mr. Byron, Ms. Ledoux. I'm going to read some identifying information into the record, and then we'll begin our interview. So I find, sir, that you are a third felony offender, currently serving a 40-year sentence for a manslaughter. And you have a parole eligibility date of 7/24/26. That's you have a good time date, or I mean a full-term date of 7/24/46. Does that sound correct?
Yes, ma'am.
Okay. Mr. Newman, you have a large number of people here in support of you today. At the appropriate time, we will hear from them. But first of all, I'd like to start out by asking you to tell us why you're here today, what you did, and also why we should consider early release.
All right, thank you. If it's all right with the board, I will be reading the statement that I have prepared. Due to injury to my brain, I have trouble retaining thoughts and somewhat memory loss. I didn't want to leave anything out because it's very important to me to say what's in my heart. First and foremost, I would love to extend my remarks to Mr. Bourne's family and loved ones. What I did was wrong in the eyes of God, wrong in the eyes of the law. It hurts me that the Bourne family have to relive the pain, all the trauma here today. Again, I am truly sorry for the lifelong suffering and heartache that I caused that family. I'm here today because in 2006, I shot and killed Mr. Clifton Bourne. I knew Mr. Bourne from the street life we both lived. At the time, I was afraid he would kill me. I responded in the only way that I knew how at the time, with violence. I went to his home and killed Mr. Bourne while his wife and kid was in the next room. I forced Miss Tyra and her 2 young kids to live life without a husband and a father present. I did that. What I did was sensitive, revengeful, horrific, and selfish. That kid was just 1 and 3 years old at the time, innocent baby. It hurt deeply just thinking about them missing out on their lifelong or everything because of me. Birthday, first day of school, graduation, and holiday. Just all the life precious milestone that a father had with his kids. I robbed him out of that. Nothing in all this world could fill that void that I have created in their life. It's a regret that will be with me for the rest of my life. I went to prison for armed robbery and attempt murder, did 5 years and returned home the same man that I went in. I found myself back doing time for drug-related charges a year or 2 later. I grew up in the street receiving influence in all the wrong places from all the wrong people. I can honestly say I'm a changed man. I now a leader and mentor. I have facilitated 5 churches where I have helped others to make healthier churches. I say all that to say, I know how lucky I am to have a parole date. And after serving 20 years, I'm asking the board for grace and mercy. This is my 3rd offense, but the first 2 times, I basically returned home the same man that I went in as. The only thing that I did accomplish the first time was my GED. This time, I have rehabilitated. I took programs that helped shape me and change me to the man that I am today, loving, compassionate, and of a service to others. Today, I am transformed, humble, and most importantly, my faith in God is stronger. Through the many programs that I have completed and facilitated, I have changed the way I think. Even though I didn't have a drug addiction, I recognized selling drugs was a problem in itself. That's why I still took living in balance to help me understand how selling drugs victimized the community. Anger management has taught me how to regulate my own emotions and manage conflict in a positive way. Facilitating higher level of thinking allowed me to teach others the importance in thinking of the inconsequences of every decision they will make. I also completed victim impact. I didn't get rewarded good time credit. It was personal. I now understand how a bad decision can permanently affect innocent people, how victim families are forced to carry the pain, trauma, and emotional damage long after the actual crime. I now know the ripple effect I have caused the Bond family, my own family, as well as the community, because Mr. Bond was known for giving free haircuts to kids in the neighborhood. I'm no longer the problem. I am part of the solution. I now help to teach others how to deal with positive decision-making, fatherhood, and peer pressure. I'm asking the board for another chance, a chance to help rebuild the community in which I helped tear down. And I do recognize no amount of time, program, nor apology will ever be enough to repair the damage I have caused. I am respectfully asking the board to grant my parole. It would be an opportunity for me to continue mentoring at-risk youth, hospice work, and be a positive force of change for others on the outside. Thank you.
Thank you very much. I can tell you put a lot into that. Warden, what can you tell us about his time there at your facility?
Norman Newman's been, we know, locked up almost 20 years. He served as a dorm here at the prison trustee, so he can be counted on to help out on the compound and stuff. He's been at Hunt since 2015. So I know that he's known around the prison for helping out where it's needed.
Looking at his disciplinary report, can you confirm his last write-up was in, well, not his last, but in August of 2022, he was written up for a cell phone?
We just sent that paperwork over. It was yeah, it was an extension cord.
Thank you, staff. I'm referring to the, has on my report on August of 22, it was a cell phone. Do you have a cell phone write-up in August of 22?
The cell phone write-up that I had, it was during the time that I was dealing with an issue, a family issue with my family. My sister had been shot, and nephew was killed. I did take responsibility for the cell phone because it was illegal in prisons and stuff. But since then, I ain't have no other write-up. I have been in compliance with all prison rules since then.
Okay. Okay, thank you for clarifying that. We have several people who would like to speak on your behalf. We'll ask Mr. Myers if he wants to speak first.
Thank you. Good morning, Kerry Myers with the Louisiana Parole Project. On behalf of Norman Newman,
We've been working with Mr. Newman for quite a while. And one of the things that stood out to us about Mr. Newman was his service, his volunteering ship as a hospice volunteer, which is not only commendable, but a very difficult thing to do, to attend to another dying person. That certainly speaks to his humanity. Also, he's worked in the visiting shed concession, a trusted area for a number of years. And that, again, service to his community. This is about his trajectory. His disciplinary record is good. He is programming, living in balance, anger management, victim awareness, victim impact, Malachi dads. He's certainly put in that work. He's going to be a long-term client of Parole Project. We will assist Mr. Newman rebuilding his life. And that's going to include employment assistance. That's going to include case management and mentoring and technology, financial management and planning, social norms, consumer skills. He'll be evaluated by our social workers for any recommendations, for any additional assistance. Mr. Newman has been very candid with this board about his past. This is about trajectory, and the trajectory since this period of incarceration, the maturity, the age he is at now, has put Mr. Newman on a completely different path. We believe that he will be an excellent candidate to succeed, and we ask this board to consider those factors and grant his parole today.
Thank you, Mr. Myers. We also have Mr. Newman's sister, Tamika, who would like to speak.
How y'all doing?
Good. Yes, we can see, and just speak loud.
Okay. My name is Tamika Newman, and I'm the sister of Norman Newman. First, I want to thank the members of the board for allowing me the opportunity to speak on behalf of my brother today. Before I say anything else, I want to acknowledge the Burns family. To the Burns family, we continue to offer our deepest condolences. We have never forgotten your loss, and we know nothing can erase the pain that was caused. We pray for your family and continue to respect the weight of what happened. Standing here today is not easy, but it's important because I want you to know the man I know, not just for the mistake he made over 20 years ago, but for the man he has become. When Norman made the decision that brought him here, I was angry, disappointed, and heartbroken. I knew my brother was capable of so much more. I could still hear my mother telling him that he could be the president if he wanted to. Those words stuck with me all these years because she saw greatness in him. Sadly, one decision changed the course of so many lives, including ours. Growing up, Norman had a good heart. He was always helping people, especially the elderly, and he loved his family. He made wrong choices as a man, but those choices did not define the person he is today. Over the last 2 decades, my family has remained by his side. We have visited him constantly, talked with him on phones, writing letters, and never stopped believing that he could be a better man. Those visits was never out of obligation. They were out of love. They also represent the strong support system waiting for him when he comes home. He will not be returning to society alone. He will be surrounded by family who love him, who hold him accountable, and will help him continue on the right path. Throughout these years, I have watched my brother grow. Every conversation has shown me someone who is more mature, more humble, and more thoughtful than the young man who entered prison. He accepts responsibility for his action. He didn't make excuses. He understood the pain the charges caused. And he has spent years working to become a better man through rehabilitation, self-reflection, and personal growth. Even the correctional officers have shared with me the kind of man that they know him to be. When they see me come and visit, they often smile and tell me how respectful, kind-hearted, and helpful my brother is. Hearing those words bring tears to my eyes because they have come to know the same Norman our family has always known beneath the mistake, the real Norman Newman. Norman has always remained a family despite being behind prison walls. I have stayed close to all his children and I have watched him continue to love and support them through phones, letters, guidance, and encouragement. They have grown into positive young adults, but they still need their father's presence, wisdom, and support outside these walls. Norman's daughter, who is incarcerated next door at LCIW, asked me to share from her heart. She said, my father was young and made a bad mistake, but I've seen him change. I need my father and I believe he deserves a second chance. Those words carry great meaning because they come from his own child. Norman is more than my brother. He has always been someone I could call whenever I need him. No matter what was going on, he was there for me and for our family. Losing him affect all of us. His decision didn't just change his life, it changed our family life as well. As I look around this room today, I see people who came here for one reason, to show Norman love, support, and stand beside him because they believe in the man he has become. That speaks volumes. These are people who know him, who have watched his growth, and who are committed to helping him succeed. Ladies and gentlemen of the board, my brother is ready. And I'm sorry. He has been genuine, remorseful from the very first day of his incarceration, and their remorse remains with him today. His actions over the last 20 years have shown that he has done everything within his power to rehabilitate himself. He has prepared himself for the opportunity to become a productive citizen again. And if granted parole, I truly believe he will never ever make the same mistake that brought him here. Besides the parole project, our family is prepared to support him and will encourage him. People cannot rewrite their past, but they can choose a different future. I respectfully ask this board to consider not only the terrible mistake my brother made as a young man, but also the man who stands before you today, a man who accepts responsibility, shown remorse, demonstrate rehabilitation, and earn the opportunity to prove himself with outside these walls. I truly believe Norman Newman deserves a second shot chance. Thank you, and thank you for your service.
Thank you. We'll take all that into consideration. We also have your son, Norman Newman, and you'll provide brief comments. Your sister provided a lot of your aunt provided a lot of information. If you'd like to speak.
How you doing? I just want to thank y'all for y'all time. And growing up, it was really hard. Growing up, it was really hard. I wish I had my father for the small things. I just wish he was there on a daily basis. Wish we could do everything that we wanted to do as a kid. I'm sorry. I apologize.
Okay.
I think my father deserved a second chance at life because
It's okay. We understand. We understand your sentiment. Thank you so much. Thank you. Also, Hannah Burdell, the attorney, is here at headquarters. And you can speak at this time.
Good morning, Honorable Board. My name is Hannah Rose Burdell. I'm a staff attorney with the Louisiana Parole Project. I'm here on behalf of Mr. Norman Newman. Before I begin, I want to extend on behalf of Norman and the entire Newman family sincere condolences to the Barnes family. Nothing can undo the loss I had to carry for 2 decades, and nothing I shared today minimizes that. The question for this board is whether the Norman Newman before you today is prepared to safely re-enter this community under supervision. Norman has spent every day of the last 20 years answering that question through his conduct, and I am here to confirm without hesitation that he is. The Norman Newman you meet today is humble, deeply kind, and genuinely remorseful. His transformation is reflected in 20 years of accountability, faithful service to others, and dedication to his family and community. And since the full scope of that transformation is reflected in the countless certificates, court letters, and achievements submitted to this board, I'll just highlight a few points. First, I'd like to briefly provide context for his offense, not as an excuse or justification, and certainly not to assign blame to Mr. Barnes, but because the circumstances that shaped Norman's life illustrate the significance of his transformation. In 1998, Norman was shot in the head and shoulder, leaving him permanently deaf in his left ear. In 1999, he was shot again, this time in the face and neck by Mr. Barnes, wounds that left Norman with lasting injuries, including documented memory impairment and partial face paralysis. Years later, believing that his life was in danger yet again, and having been shaped by a world of violence and fear and survival, Norman made the horrible decision to confront Mr. Barnes himself. Norman has always maintained sole responsibility for his decision and the tragic consequences that followed. And in fact, accountability has shaped Norman's response from the very beginning. He pled guilty to manslaughter, but more telling is that on the day of his sentencing hearing, long before any rehabilitative program, Norman, on his own initiative, asked that an apology letter be hand-delivered to Ms. Barnes in open court. That moment shows Norman's remorse did not begin in prison, nor was it motivated by the possibility of being granted parole. It began with his own recognition that he had caused irreparable harm. And for the past 20 years, that remorse has fueled his commitment to living a different life. Despite the limitations imposed by his medical condition, Norman has addressed every factor that led to his incarceration, completing extensive therapeutic and rehabilitative programming, but he didn't stop there. He went further, and became somebody selected by the administration to teach and support others. Norman is now a facilitator, a certified hospice worker, and a trustee of over 5 years, exhausting every opportunity available to him at the prison. The agency that has supervised Norman for the past 20 years has repeatedly recognized his rehabilitation and readiness for reentry. In 2025, Norman's assessed risk level was so low, he was not accepted into the Thinking for a Change program because he no longer met the criteria for that intervention. And in 2022, the warden wrote in a letter submitted to you, quote, Norman Newman has fulfilled all aspects of his incarceration and is prepared to return to full-time employment. End quote. This collection of photos submitted to the board with our brief tells the story of a devoted father who, despite decades of separation, has made strong and loving relationships with his family, many of whom are with him today. His love of his children and his vision for fatherhood are rooted in his faith in God. Granted parole, Norman will have comprehensive long-term reentry support through the Louisiana Parole Project. He will return to structure, accountability, and a strong community. prepared to help him succeed. Norman has accomplished the goals of corrections. He has accepted responsibility for the harm he caused, demonstrated sustained rehabilitation over 2 decades, and prepared himself for a safe and productive return to the community. The record of this board shows Norman no longer presents the risks that brought him to prison. Rather, he's become someone who enhances public safety through his service, through his leadership, and his ongoing accountability. Today, we hope we can see him as we do: a teacher, a leader, and a father. And for these reasons, and reasons more fully outlined in the brief submitted to you, the request this board grant Mr. Norman Newman release on parole supervision due to the program and support of the Louisiana. Thank you.
Thank you.
Executive session.
We've got a request for executive session. Go ahead.
A second.
All right, friends, we'll let them do their executive session-y thing, and then we will come back to them. Great Granny asks in the chat, is it normal that parolees come before the parole board incarcerated for 20 or more years? Honestly, it's all over the board. It kind of depends on what they were sentenced to when they become eligible. So it's not a hard and fast after 20 years. It just kind of depends on the situation. Let's go... Keeping this channel's promise of 9 to 11% more, Judge Boyd. Let's go there. We'll do a hearing with her, and then we'll come back to the board.
2021 CR 9153, State versus Tony Lee Barrera. Can I have parties announced?
Yes, Judge. Brandon Prayer for the state.
Albert Chidas for Mr. Barrera.
And are you Mr. Barrera?
Yes. You're
Did you review the document entitled Motions to Enter Adjudication of Guilt and Revoke Community Supervision and State's motion to supplement pending motion to enter adjudication of guilt and revoke probation with your attorney? Did you understand it?
Yes, Your Honor.
Are you the same Tony Lee Barrera who was placed on deferred adjudication in 2021 CR 9153 for the offense of evading arrest detention with a vehicle on December 3rd, 2021 for a period of 4 years? Is that you?
Yes, Your Honor.
State?
Judge, I'm qualified. I do not have a copy of the MTR.
Yes.
My apologies, Judge.
No problem.
We proceeding on a violation of condition number 4, specifically that in Impaired County, Texas, the defendant, Tony Lee Barrera, the defendant there fails to report to the supervision officer as directed for the months of May and June 2025 and violates condition number 4.
How do you plead to that? True or not true?
True. The state will waive the remaining allegations.
Any objections to the waivers?
No objection, Judge.
Did you understand by pleading true to violation of condition number 4, the court could find it true, grant the motion, find you guilty, sentence you up to 10 years in the prison and up to $10,000 fine?
Yes, Your Honor.
You need to speak up.
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of condition number 4?
Yes, Your Honor.
Court will find violation of condition number 4 true. Is there a proposed agreement?
There is not, Judge.
All right, state, what are you requesting?
Judge, we're asking that the underlying term was 4 years because there is still a majority of the work to be done and the term has already been expired. We ask that the judge sentence the defendant to 4 years to his loss.
And Judge, we're asking that the court extend him. And I'd like to call my client as a witness just to explain to the court what's been going on in his life.
Can you raise your right hand for me, please? Do you solemnly swear or affirm the testimony you give will be the truth and nothing but the truth, so help you God?
Yes, Your Honor.
All right, you can lower your hand, state your name for the record.
Tony Barrera.
All right, you may proceed.
Thank you, Judge. Mr. Barrera, you've been on probation since 2021, is that correct? Okay, and you know you had to report to probation, you had to do everything they asked on that list of services that you need to complete?
Yes.
And had you been reporting regularly when you first started?
Yes.
And here's the violation report indicating that you stopped reporting and that you didn't do drug testing.
Okay, I'm so sorry, counsel. If you could speak up because I know
Sorry.
court reporter's having a hard time hearing. I am as well.
Now, there's an allegation that you stopped reporting. Is that, and you pled true to that? You understand that, right?
Yes.
What happened in your life that changed things?
My brother was murdered, and a few months later, my grandma got sick and he passed away too.
And what did that do to you? Why did you stop reporting?
It messed me up. Like, I don't know, I just got depressed.
Now, if the judge were to consider keeping you on probation, do you have a place to stay?
Yes.
Do you have any family support?
Yes.
Who's there for you?
My dad and my mom.
Do you have any chance of employment?
Yes.
Where, doing what?
Construction, laying pipe with my dad.
Okay, and before this arrest for this offense, had you been arrested before?
No.
And you're on deferred adjudication probation. You understand what that is?
Yes.
And you understand that if the judge revokes you and sentences you, that you'll be a convicted felon?
Yes.
And for that reason, are you asking the court to give you another chance?
Yes.
Okay, thank you. No further questions, Judge.
Any questions?
Two questions, Jeff. First of all, simple answer to lost my condolences. When did your grandma?
I want to say in 2014, 2015, around there.
2015.
2014, 2024, 2025, around there.
Okay, and do you remember like what month?
No.
Okay. Was it summer, was it spring, winter?
All blurry. I don't remember.
Okay, that's all. So after your grandma passed, when did you try and get back in contact with probation? You ever get in contact with probation?
I don't think I did.
Is that because you knew you might have a warrant out for you?
Kind of, sort of.
Thank you. There you go. Pass it.
All right, when's the last time you reported? Has it been more than a year?
No.
All right, so when's the last time you reported?
I would say like 6 months, 5 months ago.
Probation, when is the last time he reported?
April 9th, 2025, it was a virtual office.
Nobody's seen you. I don't think you're a good candidate for continuing on probation. I'm going to grant the motion, find you guilty. There's to be no contact with Leroy Gomez and Isaac Hernandez. And I'm going to sentence you to 3 years in the prison, give you credit for any time served, and I'll request the therapeutic community. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes.
All right, you have a limited right to appeal. That right to appeal is as it relates to the allegations in the motion, not the fact that you're on deferred adjudication. Because this is a felony conviction, you're not allowed to own or possess any weapons or ammunition. If you have any questions over what that is, you'll need to speak to an attorney. Do you understand?
Yes.
All right, so here's the thing. Nobody's seen you. The simplest thing you can do is report. Everyone knows if there's an issue, I always tell people, just let probation know about it. You know, I'm not a revoke happy judge. I will listen and figure out what's going on with you and see if you need help with something, and I'll try to get you the help that you need. But you cannot just disappear. Okay? Good luck to you.
Thank you.
You're welcome.
Thank you, Judge.
Alrighty, friends, we're going to return to the board here in just a second, but to clear some things up, because Gigi was asking in the chat about eligibility for when they can start seeking parole in Louisiana. First-time non-violent offenders are eligible after serving 25% of their sentence. Crimes of violence are different. First offense is 65% of their sentence. If they're in there for a second offense or a first offense, if it's a sex crime, 75% of their sentence. 3+ convictions for violence or sex offenses, they are ineligible for parole. A non-violent habitual has to serve at least 65% of their sentence before they're eligible for parole. And there are some other exceptions and whatnot that are built in, but that's generally the gist of it. All right, let's go back to the board, see how they finished up here.
We've returned from executive session, and seeing no opposition, we'll continue our hearing. I do want to note that we had the opportunity to receive and review the 187-page document from the parole project. So thoroughly familiar with all of the letters of support. There are numerous people here today in support, and I would like to name them for the record, and forgive me if I get your name wrong. This is both Zoom, Addie Lane Hunt, and at headquarters. Josie Elsie, Ziki Wiltz, Alexander Angel, Christy Acri, Samuel Mack, Tamika Newman, we've heard from her, Chakiwa Newman, Vonda Blackwell, Gilda Newman, your other sister, Razzie Gibbons, and another sister, Janika Newman. Excuse me if I mispronounced your name, but those are the people that we have listed today as visitors. So, Mr. Newman, I want to commend you that one thing that you did very well today was own your responsibility. You acknowledged your previous behavior and you owned your responsibility. And you have been doing some significant work in your rehabilitative process. I need to make note that this was a first-degree murder charge that was pled down to manslaughter. If I'm not mistaken, maybe your co-defendant is still serving a life sentence. The severity of the crime is, with your history, is something that gives me pause. So today, based on the totality of the case, my vote is to deny parole today. Yes, okay. We would like to, Mr. Tillis would like to ask a question.
Mr. Newman, in your statement, when you began your statement earlier, you said you were in fear of your life. What were you referring to?
What I was referring to?
Yes.
All right, I have been, in the past, I have been shot on 2 occasions. Once by Mr. Barnes, was responsible for it. So when I got word after Katrina, I got word that he was looking for me. Family members and friends were telling me he was coming around looking for me and stuff. So I went looking for him. You know, that's what I was told growing up. You know, that the life that I was into, I was scared that he was gonna kill me or shoot me again. So that's what I meant by that.
Okay, thank you.
So I stand by my my vote for denial. You know, you were there perpetrate violence that day. Mr. Tillis?
My vote also is going to be to deny.
And Mr. Butler?
I'm also going to vote to deny parole also, but I just want to let you know you're on the right track. The classes you're taking, the work you're doing, the things you're doing, stay on that track, stay right up free. And come back and see us when you're eligible again.
The answer is not no, but it's not today. And today it's no, but it's not never. So just keep doing what you're doing, okay?
All right, thank you.
Alrighty, friends, the board went against the vote of the crowd. 56% of you thought that they would grant parole. They did not. But this is why we watch, because we never know what's going to happen. Hour 3 of TCF Live on this Thursday. My name is Dan, and it's good to have you here. Probably some new people out there. If you've not yet said good morning, please do take a moment to say good morning to us in the chat. We would love to hear from you. Let's go up to Michigan. Let's check in with Judge Aquilina. She's got a new contestant there.
This is docket 18500FH, People of the State of Michigan versus Justin Ronald Garcia. Counsel, your appearance for the record.
Good morning, Your Honor. APA Bart Buxton on behalf of the people of the state of Michigan here with probation.
Good morning, Your Honor. Agent Jessica Farr with Ingham County Probation Department of Corrections.
And good morning, Your Honor. Frank Harrison, Ingham County Public Defender's Office, speaking at a normal speed here on behalf of Mr. Garcia, who appears in person and standing to my right.
Appreciate that, counsel. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth, and the perjury?
I do.
Thank you. And put your hand down. Are you taking any medication, using the alcohol or marijuana yesterday or today?
Medication, yes, no alcohol or marijuana.
Does the medication interfere in your ability to understand your attorney or the court?
No.
Is there medication you're supposed to be on that you're not on?
No.
All right. And you had enough time to speak with your attorney?
I'm sorry.
You had enough time to speak with your attorney?
Yes, Your Honor.
All right. You pled guilty to uttering and publishing attempt, which is felony punishable by 5 years. You were placed on probation. Part of your probation included that you would participate and complete the House of Commons. I now have a bench warrant that was requested, and this was done I signed it. It was requested by then probation agent Justin Russ. I signed it 6 years ago, 20th of August, 2020. So just shy of 6 years. And it alleges that on August 21st, 2020, defendant absconded from House of Commons. Counsel, you're waiting for the arraignment.
We would, Your Honor.
Will there be a plea or a hearing?
My client is prepared to plead as guilty as charged, Your Honor, or responsible as.
All right. And sir asked, did anyone force, threaten, or coerce you to plead?
No, Your Honor.
Anyone promise you anything to cause you to plead?
No, Your Honor.
And you are pleading after consulting with counsel?
Yes, Your Honor.
And you've been satisfied with the representation of counsel?
Yes, Your Honor.
As to count 1, on August 21st, 2020, absconding from the House of Commons, how do you plead?
Guilty.
Sir, you understood as part of this agreement that you needed to attend substance abuse treatment. I had recommended, I think I put Red Cedar, maybe somebody, I don't remember, from 6 years ago. I've done thousands of cases since. But I did order continue to attend substance abuse treatment and provide verification of attendance. At that time, I wrote a note to myself about Red Cedar. It's possible that there wasn't a bed or that there was an agreement to House of Commons, which is fine with me because I usually say, or when a bed becomes available. So you understood clearly that you were to complete treatment, correct?
I did, Your Honor.
And did you ever enter Red Cedar?
Not Red Cedar. I went to other ones while I was absconding, but not Red Cedar.
Okay, while you were absconding, but what about, did you enter House of Commons then?
No, I turned myself into House of Commons before I saw you. He had me arrested.
I got that.
But
I'm
no,
talking about the order, and then we're going to talk about all the other things you want to tell me.
Okay.
Happy to listen, but right now, did you after I put you on probation, enter the House of Commons?
I walked in for a very short time.
And then you walked out?
Correct.
So you did not attend and participate?
Correct, Your Honor.
Okay. Based on that acknowledgement, I find that you are guilty of violating probation, and I don't think it's disputed in this record or from you that you violated probation. So based on preponderance of the evidence, you are guilty. Maybe go into sentencing?
If Your Honor would so.
First of all, before I turn to Ms. Farr, have you talked with her?
I'm sorry.
Have either one of you talked with Ms. Farr, the probation agent, this matter now?
My understanding, his probation agent is actually Leanne Brown, Your Honor.
I don't know. You know what? In 6 years, there has been so much transition. I don't know. Have you talked to that agent?
She emailed me, Your Honor. We had some cursory conversations, but nothing in substance.
Okay. Ms. Farr, was he able to complete anything while on probation?
Your Honor, just so the court is aware, Ms. Brown had a death in the family, so that's why she's not here today, and I
appreciate you standing in.
Yes, of course. 6 years ago, he completed more cognitive therapy. He did not complete residential or outpatient substance abuse treatment. So he only completed MRT.
And then what about, I have 2 jail days. Do you know if he ever paid back? Was it a restitution? This is so old, I'm looking at my notes. Looks like it was just probation oversight and the regular cost, but there was no restitution, is that right?
I believe so, Your Honor, that's correct.
Okay.
And this would be his second violation of probation, as the court may be aware. On July 30th of 2020, that's when he was ordered to 365 days jail with credit for 12 days served at that time, at which point the jail was going to be suspended for him to enter House of Commons, now known as Cedar Roots, and he failed to do so. I have more to say, so whenever you're ready for me to give
so he has 12 days jail?
As of today's date, since being placed into custody on June 25th and released on July 7th, he has a total 45 days jail credit, Your Honor.
And so, okay. All right, what else would you like me to know before I turn to counsel?
Thank you, Your Honor. So since he absconded, so I've read the letters, he may not be mine, but I've read the letters that we've received from the court from him, and I believe a recovery coach that he's working with. He's been gone for quite an amount of time. So I understand that he has stable housing now, he has employment, he has gotten his real estate license. In quote, I never ran from this. I was home in Lansing. But I've seen that so many times, and I just cannot understand the thought process behind that. If you were here and you were doing well, then let's get this matter taken care of, turn yourself in and get going. Not when you're arrested and now you want to bring all this positive stuff in front of the court. So I don't understand the thought process behind that. He has a significant history with the use of drugs and alcohol. He was, positively speaking, he was tested at Aberhall on July 9th. He was positive for benzos. I don't know if he has a prescription. He did not provide that to Ms. Brown. I'm assuming he does. His test on July 13th was negative. But Your Honor held that jail in abeyance. He's been gone for so long. If he truly is doing this well in the community, revoke probation. I will leave it up to the court with the amount of jail ordered. Again, 365 days was held in abeyance.
So are there new charges? Do you know, or do people know?
There are none in our system, Your Honor.
Not that I'm aware, Your Honor, no. It was just a probation violation that he was picked up on.
All right, thank you. Counsel, what would you like me to know?
Thank you, Your Honor. Well, I mean, probation has kind of sketched what exactly I was going to tell Your Honor. It's just on a different perspective. Yes, my client recognizes that he ran. He tells me that he got messed up when, COVID came around and he did some silly things. He fell off the wagon and he ran from it. There is no argument to that. Obviously, there is no way of squaring that. The question comes down to, what did he do afterwards? Well, he's done well. He's got his real estate license. He's got a job. He tested positive, and he tested negative just recently. He's trying to do the right thing. He just didn't do it the right way is. So obviously he didn't do the right thing. He's just asking Your Honor for leniency here. The way I framed this case when I was thinking about it is, are we punishing the same person that was before Your Honor in 2020 when they absconded? And the answer is not really. I mean, it's the same person, but it's a different person than it was then. When he was in 2020, he was on drugs. And when he relapsed and he absconded, he was on drugs. Today, he is not. Today, he's clean. Today, he is trying to do his best, Your Honor, and he has to make amends for the fact is what he did in the past. Are the good things that he's doing now, did that make up for it? Absolutely not. It doesn't wash away the fact is that there are some things he has to answer for. But at the same time, we just hope Your Honor takes into consideration that he is trying to do the right thing now. He could have ran from this hearing. He didn't. Your Honor graciously gave him an adjournment. This case was supposed to be heard yesterday. However, he had a dental appointment that he could have availed himself to. He did avail himself to. I'm told that it was more complicated than what they thought, and they're trying to give him a rescheduled point. But at the very, the point I want to kind of hit home here, Your Honor, is he's no longer running from this. And yes, he does have to answer for that. Yes, he's in front of Your Honor to do so. We just ask Your Honor to give him some grace, understanding that he's done some good things, and just take that in consideration during your sentencing.
So what's the relationship with your grandmother? She was the victim, wasn't she?
Yeah, the case started her. The relationship is she lives down south now. I don't speak to her as much as I used to. We were real close when she lived up here, but now she's really far away. But as far as the case, everything's fine. I'm talked to her. It was a loan. She showed up for sentencing to say that. That's why they dropped it to one count of attempted uttering and publishing. In reality, the loan was more than one check. So, yeah.
And it says that you were addicted to and abused Vicodin, Oxycontin, heroin, all of that. So the medication that you're taking now, is that for your back pain? Do you have a prescription?
It's Subutex for opiate addiction. It's MAT therapy. You heard of that? MAT. I finally got on it. I had
how long have you been on that?
Since the 24th of June. I actually got the Subutex in jail. I have an allergy to naloxone. So all these times I went in and out of rehab while I was absconding, I couldn't take any MAT. Everybody else had MAT, but I didn't. And I wasn't able to complete the programs. And it just so happened when I went to jail, they had the medication I was seeking out here the whole time, Subutex. There's no naloxone in it, so I could take it. And
that's why you show up to probation. Probation agents are really smart. They would have gotten you that help. That's why you're accountable. You know, you're in real estate. People are going to have to trust your judgment. You're going to be working with mortgage lenders and all of that. They need to trust you. You need to be accountable. What have you learned from all this?
One, I can't use drugs. And two, just like you said, I just need to be more accountable. I need to meet things head on and not put things off, because everything gets worse when you put it off.
Are you in treatment?
No.
All right. Therapy?
Therapy, no. I just go to NA every day. I've only been out of jail a couple of weeks. But yeah, I know I need to do some brief therapy. I know I need to do some things. So as of right now, it's just NA, Your Honor.
So you have, how are your children doing?
They're doing great.
Would you see them, pay support, all of that?
Oh, they're not children anymore. They're grown. My son's here in court.
They were minors when this happened. So
yes.
You pay support and do what you're supposed to do, or it's their arrearage?
No, I paid all support for my daughter. There's never been support for my son. And I did pay all the fines for the probation when I was on it.
On behalf of people, any comment?
Your Honor, just to correct the record, I do see that there was restitution order at sentencing of $1,536 to Flagstar Bank. I'm not sure if that payment was ever made or not. But I do see that that was written, so I just want to make sure the court is aware of that.
Okay, did you pay that, sir? Were you aware of that?
Yes, Your Honor, it's paid.
Okay.
And I completed both the classes I was in. The one I think is called PATS on Waverly,
Yeah.
and then one more I did.
All right, sir, I'm gonna give you 45 days, credit for 45 days to close this out successfully because you've done what we would have done had you stayed on probation. Sadly, you were on the run for 6 years. Was it worth it? You must have thought about this every single day.
I did.
Every time you saw a police officer, and there's a lot of them in this community, your heart had to jump.
Yeah.
Do the right things, make amends, be accountable. I don't have to do this successful. I'm only doing it because I think that you did accomplish the things that probation and I were watching. So congratulations for that. But understand, sir, everything that happens in life happens for you, not to you. For whatever reason this happened to you, learn the lessons, be accountable, be an example to your children in this community, and, you know, help others stay free of drugs and make our community better, not worse. This, you robbing your grandmother essentially is horrible. You really owe her an apology. And I would recommend, sir, that with this gift, you give her the gift of a phone call and a thank you and an apology. She's in her 80s, she's not gonna be with us that much longer, and you owe her. Make that phone call.
All right.
What time does she go to bed? 8, 9?
No, she stays up late.
Well, before 8 o'clock today, you make that phone call. Your son is here?
Yes.
Sir, you make sure your dad calls grandma.
Yes, sir.
Because otherwise, I'm not gonna be really happy.
All right.
Thank you. It's all for the record.
Thank you, Your Honor.
Thank you, Your Honor.
Alrighty, friends, hour 3 of TCF Live. Dog Mom sent a floating heart. Thank you for that. Michael Groff, 14 months as a channel member. You know, 14 months, I didn't know who you were, even though we live pretty much in the same area. And 14 months later, not only are you a fixture on this channel, you've become one of my best friends. So thank you so much. And Todd, celebrating 3 months, says, throwing handcuffs around the room. 3 months of that. Todd, knowing what I know of you, you might be talking about something else there. But we'll just let the mystery stand. Okie dokie, let's go to the Commonwealth of Kentucky. Judge Williams, let's check in on him.
I'm Blakely. Okay. Good morning. This is 26 CR 0051. Mr. Blakely, were you born in 1989?
Yes.
Last 4 digits. Okay. What does the Commonwealth have to say about this?
Your Honor, we have a new case going to the grand jury today, so if we could have negotiation on the 7th, we'll furnish Mr. Parent the paperwork on it, and hopefully we can.
August the 7th?
Yes.
And next court date would be August the 18th.
Yes, sir.
Okay, thank you very much.
Yes.
Joshua Geralds. Commonwealth versus Joshua Geralds, 26 CR 0048. Are you Joshua Geralds? Good morning. Were you born in 1989?
Sorry.
Last 4.
Sorry.
What does the Commonwealth have to say about Mr. Gerald's case?
I understand is DPA wanted some additional time to do some investigation.
That is correct, Your Honor. We could get another.
What is the charge?
I'm trying to remember, and I'm drawing a blank. It's a serious case, so I'm trying.
This is trafficking, wrong endangerment.
Yeah,
First.
Significant amount of drugs. What I remember.
What kind of time frame are you talking about?
Just pass it to the negotiation next month.
August the 7th for negotiation, and August the 18th.
Yes, sir.
For the next board date.
Thank you, Your Honor.
Didn't find his file.
Stephen Hammonds. Commonwealth versus Stephen Hammonds, 26 CR 0041 and 26 CR 0023. Are you Stephen Hammonds? Good morning. You born in 2000?
Yes, Your Honor.
This is a sentencing here. Last 4 digits 41.
Yes, sir.
Have you had an opportunity to look at the pre-sentence investigation report of a probation and parole? Is it substantially correct?
Yes, Your Honor.
Counselor, is there any reason this gentleman should not be sentenced?
No, Your Honor.
I plead guilty in indictment number 26 CR 0023 for charge of assault third. And shall receive a sentence of 3 years, but I plead guilty indictment 26 CR 0041 for the charge of burglary third. Defendant shall receive a sentence of 4 years, but I plead guilty to on 26 CR 0041 for theft by unlawful taking over $1,000. Defendant shall receive a sentence of 3 years. 4-year sentence and 3-year sentence shall run consecutively for a total of 7 years. The 7-year sentence in 0041 and the 3-year sentence in 0023 shall run concurrently for 7 years, serve 180 days in jail with balance probate for 5 years. He shall enter and complete the specialty court. Has he been voted already?
It's my understanding, Your Honor. Spending some.
Yeah.
Has there been an orientation yet?
According to the plea agreement, it's to be released today with orientation in the morning.
Okay, we'll, I don't know about that. Yeah, I don't know whether I like that or not. I think I'd rather, what time is orientation tomorrow? Does anybody know what time drug court orientation is tomorrow?
Yeah, we'll get with Mr. Graves if you can
Yeah.
contact him.
These night before orientations bother me sometimes, so. I know the plea agreement says that. What's the court cost in this case? You need some time to pay that probably. $290 court costs.
$290.
$290 court costs. So I'm gonna let you pay it $30 a month. First payment be 30 days from the day you get released. Okay? Are you with me? Okay.
So I'm
thank
not
you.
released today, right?
Well, I don't know whether you're gonna, I'm gonna ask when the orientation, it either be today or early in the morning, one or the other.
We've seen him make some
So we'll tell you that it'll either be tonight or is he gonna have somebody come pick you up?
Today? I believe he would be able.
Whenever you get picked up, are you gonna have somebody pick you up or are you expecting to stay here?
Yes,
Okay.
Your Honor.
Okay, I just want to make a contact. The problem I've got is sometimes when you let people out the night before, there might be a little binge, something going on. You think you can handle it all right?
I can handle it.
Okay, well, I'm gonna let you
All
out.
for it, 100%.
Okay, well, I'll let you out today then. Okay,
Yes, Your Honor.
okay, and your court costs will be $30 a month. First payment paid. You be sure you go there to orientation and don't get out of a bad start, okay?
No, I won't.
Okay, well,
100%, I promise.
okay, well, good luck to you.
Thank you, Judge.
Yeah.
God bless you.
Jared Hopkins. Alma versus Jared Hopkins, 26 CR 0012. Are you Jared Hopkins? Good morning. You born in 1982. The last 4 digits, social security number 6546. We're here on a pretrial diversion revocation motion. You step to your left, sir, just a little bit. Thank you.
Your Honor, Mr. Hopkins has a 3-year sentence on possession of controlled substance first. He was placed in the specialty court program. He was administratively discharged due to some mental health issues. He was placed on regular probation on June the 3rd. He was positive for methamphetamine. He's referred to the SSC. They recommended inpatient treatment. He wouldn't go to inpatient treatment. He wanted outpatient. And that's the reason for the revocation motion.
Your Honor, I've spoken with Mr. Hopkins. He is agreeable to going to a long-term treatment placement. I believe that probation and parole was intending to send him to Spark, and we do have a bed letter for Spark currently for tomorrow.
And if it's a dual diagnosis.
So yes, as long as Mr. Hopkins is stable, which he does appear to be.
Well,
then they are-
it's a dual diagnosis facility is what you're asking.
Yes.
So what it
Is
is,
that yes or no? And then we'll talk about it.
yes, Your Honor, the
Okay,
answer is a
thank
little bit more complicated than that. They are able to do medication management for Mr. Hopkins.
We'll know that need to leave.
Stay with it. If you want to stay out, stay with it, okay? Okay.
And Your Honor, may I present this bed letter?
Yeah, you could give it to the clerk over here.
Thank you.
Yeah. Justin Hunt. Commonwealth versus Justin Hunt, 23 CR 0033. Are you Justin Hunt? Good morning. Were you born in 1980? Last four digits. So you're on a probation revocation. What does the Commonwealth have to say?
Your Honor, Mr. Hunt had a 5-year sentence theft unlawful taking. He had stolen approximately $4,500 from Walmart. He paid restitution in full. However, I think he was in Owensboro, somewhere near that area. He was living in an apartment and had a crossbow. And I'm hoping that he shot it accidentally through a wall. And so since he possessed a deadly instrument, I got a notice to file for revocation. That case is still pending.
Your Honor, we're going to stipulate to the violation that Mr. Hunt did acquire that charge. Mr. Hunt has expressed to me a desire and a need for long-term treatment at this point in time. He has paid off the restitution in Monroe County in full, but he does still owe significant restitution for a case in Barron County that he is also on supervision for. So we are asking for the court to give us the opportunity to find a long-term treatment program for Mr. Hunt that will
What's
address that.
the status of the Owensboro case?
I don't even think he's been indicted on it yet. Last time we checked.
Your Honor, I believe it's still in district court. I don't think it's been to the grand jury yet.
And what do you want me to do?
Your Honor, we are wanting to send Mr. Hunt to a long-term treatment program. He has expressed that he is.
Well, I don't know anything about what kind of problem he has. You don't know anything about it either.
Does he have a possession case in Barron County?
He does, Your Honor, and if the court would like, Mr. Hunt has been sober for a significant period of time leading up to that new charge. If the court would like,
Well,
Mr.
you
Hunt
know,
to explain further.
when he's not charged with possession or consumption of drugs, he's charged with a crossbow. Now,
Yes.
I don't, there's a disconnect here somewhere for me, you know, he comes in with a crossbow and I send him to drug rehab. I don't understand.
Yes, Your Honor, if we can explain further, he does have that pending possession case in Barron County based on a very recent relapse.
I'm worried about the crossbow. You know what a crossbow is?
I do, Your Honor.
They're
Yes.
dangerous.
I understand.
I'm not so sure I'd rather be shot with a gun. It depends on what location, I guess, but I'm not, you know, what's the,
Well, I can either get somebody to testify in a hearing as a witness on that incident, or we can wait and see what happens to the incident.
let's just wait and see what they do with the crossbow down in Owensboro, and I will keep it under advisement and you stay in contact.
Yes, Your Honor.
I don't know. He accidentally shot it through the wall when someone was accidentally on the other side. I don't know what's happening.
Fortunately, there's a mattress propped up against the wall in the neighboring apartment that stopped the arrow. And I think the head just came through. Thankfully, nobody was hurt, but that was the facts relayed in the.
Okay, well, I look forward to hearing that one.
Yeah.
That's interesting. Thank you. Jason Lee. I want to version Jason Lee. 26 CR 0042. Are you Jason Lee? Good morning. Were you born in 1976?
Yes, sir.
Last four digits. 2.
Yep.
8222. Okay, we're here on a pretrial conference. What's the Commonwealth have to say?
I believe we need a trial date, Your Honor.
What's the charge?
It's drug related. He's got a possession, assault third, PFO second, and we've got the lab back.
Judge, if we could get maybe one more pretrial conference, we're attempting to obtain medical records for Mr. Lee at this time. Another complication is that any felony charge, if you were to take, would automatically send him back up to Wisconsin. And so that is part of the difficulty with negotiations at this time. And so if we could just have a little bit more time to be able to get medical records to prepare for trial.
Well, I don't know how are you wanting medical records from the officer or from him?
Oh, from Mr. Lee, Your Honor. Judge, the allegation is that he kicked an officer while he was either handcuffed or tased. Mr. Lee has substantial medical history. So that is something that we are exploring. For failure to explore that would potentially be ineffective assistance of counsel, Your Honor.
How much time does he have in Wisconsin?
I don't know.
Well, that's the problem. It's usually a good idea when you're on parole from another state not to be down here intoxicated and resisting arrest and kicking officers. It's kind of that's the moral of this story.
I'll take judicial notice of your position on that. But you want a negotiation day? Here's the problem is I come over here, we just hear once a month, the Commonwealth Attorney, and we start putting everything off. We're not going to go down that route here. We'll do, is he want a trial? Is he denied he did this? He got a right to a trial.
He does have a right to a trial, Your Honor. We also
I'll acknowledge that too. Okay.
have started obtaining medical records. It's not that I have to begin. We are in the process of obtaining, Your Honor. So we're just asking.
I don't know where the medical records fall into this thing. Are they mental records or what are they?
Physical, Your Honor, and without giving away a full defense, Your Honor.
Well, I don't want you to give away a full defense, but I don't care what kind of medical problem he has. If he's kicking an officer and doing all this kind of stuff. So, unless he's got a one-legged defense that he couldn't kick an officer, I don't know.
And that's why we're exploring it, Your Honor.
Okay, the 7th.
Yes, Your Honor.
And the 18th, and you come back here on the 18th, we want some resolution or a trial, and it won't be a lengthy trial either. A trial laid out, it'll be pretty soon, okay?
Understood, Your Honor.
Okay, Ricky Lee.
Alrighty, friends, in the final half hour now of TCF Live, let's go back to Louisiana, give the board a second try here.
To my right is Mr. Byron, Ms. Ledoux. Is Mr. Davis there?
Yeah, but you gotta be quiet.
Mr. Davis?
Hello?
Hi, you're with the East Baton Rouge Parish Jail?
Yes, ma'am.
Is Mr. Davis with you?
He is.
Okay.
How y'all doing?
Hi, Mr. Davis. Did you hear me introduce the panel?
I did not, ma'am.
You see our names, Mr. Tillis,
Yes,
Ron, Ms. Ledoux. Would you please introduce yourself with your name and your DOC number?
My name is Romy D. Davis. My DOC number is 573326.
Okay, Mr. Davis, do you have a parole revocation questionnaire in front of you?
Yes, ma'am.
Okay, that indicates that you are eligible for appointed counsel, and I believe your attorney is with you today, Mr. Mitchell Connor. Is that correct?
Yes, ma'am.
Mr. Connor, would you introduce yourself?
Yes, ma'am. Good morning. Protocol being established. Attorney Mitchell Connor this morning on behalf of Mr. Romy Davis.
Great, thank you. You please feel free to interject throughout this hearing. You are providing counsel, and you may interject as needed. Okay?
Yes, ma'am. Thank you.
We also have a David Sunday, an uncle who would like to speak. But first of all, we're going to go ahead and ask Mr. Barra to read out the allegations, and you'll need to enter a plea of guilty with a statement or not.
All right. It's alleged that you have violated the conditions of your parole in the following manner. Number 2, that you failed to report to the parole in office from September 24th to February of 2026. How do you plead to that violation?
Guilty.
Mr. Davis, I advise you to plead not guilty.
Not guilty. I'm sorry. Not guilty. Not guilty.
All right. Do you want to give us a statement about that violation?
If you want the God honest truth, I had gotten arrested and I had done some time that I thought was gonna wipe out my parole. I was told by my probation officer in Avoyes Parish that the time that I had served would have wiped my parole out. So I had went to treatment at the Hope Center in Marksville. So I really, in the God's honest truth, I thought this parole was taken care of through some time that I had served.
And who was your parole officer that told you that?
I'm not sure his name. It was a guy out of Avoyes Parish. I want to say his name was Ryan Allen.
Did he ever give you a letter or a completion notice?
No, sir. He did never give me a letter, and I should have called back. I'm not gonna say I shouldn't have. I should have checked in on it, but I did not. I really thought the time had been served.
All right. Mr. Mitchell, you have anything to add to that?
So I believe in that situation, Mr. Davis, after speaking with him, he did truly believe that, he had satisfied the time for his parole based on the fact that he served some time where there was no bill, or the time that he served did not result in any charges or any violations or any convictions, etc. And he was sitting in jail for a period of time, which he believed at that time substantiated that he was complete with his parole. And when he left from that particular detainment, after having discussions with the parole officers and the parties there, it's my understanding that they told him, hey, you're right. If you have been held for 10 months, I believe Mr. Davis can correct me if I'm wrong. I believe if you've been held for 10 months, then that
Yes,
should
sir.
have satisfied your parole time, because he was on the 2-for-1 or 3-for-1 system, because the conviction was from 2020.
Hopefully you explained to him how wrong he was. Huh? That's not how it works.
Right, I did.
All
But I
right.
also think based on Mr. Davis's previous mental diagnoses, it may be possible that he did not have the intent to violate his check-ins or report. He may just have been in an altered state.
He is a
Also,
fifth offender and has been on supervision several times previously.
Say that again. I could not. It broke up.
He is a fifth class offender and has been on supervision several times previously.
Okay.
All right. Condition number 9, that you fail to communicate and provide a valid address in order for a probation and parole officer to make visits. Your whereabouts remain unknown until your arrest in East Baton Rouge. How do you plead to that one?
Not guilty.
You had been telling your parole officer where you were living up until your arrest?
He knew that I was going to treatment, in and out of treatment. They did know that.
What about where you were living? Had he seen you at your residence? Had you given him a residence to go visit?
I was living in sober living. When I wasn't in treatment, I was in sober living homes.
I see. When you were at the sober living home, you got kicked out. Why did you get kicked out of Oxford House?
Because I didn't have the money to pay.
And what about your arrest on 9/17 for 2024 for disturbing the peace by intoxication? What was that all about? How did that happen?
I'm not gonna lie to you. I was under the influence, and I'd got a little paranoid because I wasn't on my medication either. I'd actually went up to a cop and asked him if he could take me to the jail. I'm not even gonna lie to you. I was scared. I was paranoid. I ain't gonna lie to you.
So you walked up to the cop and asked him to arrest you?
Yeah, I was under the influence and I was paranoid. I was. That's the God honest truth.
All right. Condition number 10, that you failed to pay supervision fee as evident by your arrearage of $2,349. Were you paying your fees?
No, sir.
Plead guilty to that one? I don't have any more questions. I don't have any questions either.
I believe your uncle, Mr. David Sunday, would like to make a statement. Mr. Sunday? You're getting it off mute.
All right, can you hear me? I had to unmute the phone. I was having a little trouble. Sorry about that. And I've kind of heard some of it and didn't hear some of it. So I'm just want to say good morning to all y'all. And thanks for the opportunity to speak here on Romy's behalf. I'm his uncle, David Sunday. And I thought I heard a little bit about being guilty and not guilty. And I don't know if there's a confusion between what he intended to do or if it's going to hinder the reflection upon him as pleading guilty or not guilty. I think his attorney advised him to plead not guilty, but I think he is willing to have accountability for his actions. He may be a little confused as to what to say on that. So without further doing this, I want to thank you for the opportunity to speak on behalf of my nephew. I want to emphasize a critical foundational fact to the board, which is Romy has no new criminal charges. His current incarceration is strictly due to being in violation of his parole out of Calcasieu Parish. After becoming homeless, he succumbed to a severe addiction and absconded out of place out of fear and instability. At the time of his being picked up on this violation, the police responded to a disturbance call where he was found homeless and asking for financial help. So I believe the state reviewed the incident and filed 0 charges against him, recognizing that this was a crisis of destitution and addiction, not criminal intent. So presently, Romy has been incarcerated for what I believe is about 6 months on this violation. And I feel that this period served vital, an uninterrupted window of sobriety, safety, and self-reflection. So sending him back to prison to serve out the remainder of his sentence will not treat the underlying disease of his addiction. It will only stall his progress and reset his recovery clock. So to ensure public safety while aggressively addressing his healthcare and mental needs, we have actively laid the groundwork for a complete, highly structured diversion plan that is fully ready to be executed upon this board's approval. And the first thing would be, I'm working directly with a Dr. Emily Timley at O'Brien House Recovery Center, who will have Romy interviewed and placed directly into their specialized residential treatment plan. I've also contacted and actively coordinated a plan with Miss Lisa Burns, who is a social worker at the 19 JDC. She has confirmed that if the board permits, she will interview Romy and can officially begin to find placement and secure him a bed. Romy is completely prepared to sign all necessary consent forms to transfer his parole from East Baton Rouge Parish and be reassigned, from Calcasieu Parish to East Baton Rouge Parish. So in order to guarantee absolute transparency and compliance, Romy is ready to sign consent to allow his exact whereabouts, his daily schedule, and his clinical progress reports to be directly shared with his newly assigned Baton Rouge officer at all times. So we won't have any dark zones of his supervision. And as his uncle, I am here before this board and am personally guaranteeing his compliance. If the board allows him to enter this treatment track under the East Baton Rouge supervision, I give my word that if he leaves this program prematurely, misses a check-in, fails to report, gives any premonitions of departure in the least little bit, that I will directly contact his parole officer and report his noncompliance immediately. So I would like to finally conclude with a word about what my personal observation of Romy has been. And I've been knowing my nephew his entire life. And this is the absolute first time that I ever seen Romy attempting treatment along the way of his supervision, or honestly admitting that he has a problem, rather than placing the blame on everyone and everything else around him. So he is actually actively trying to seek treatment on his own. And if the board could consider the fact that he would have probably just violated himself with the time that I'm understanding that he would probably be about ready to discharge on parole as it is anyway. So, yet he stayed the course to get this parole board hearing and ask for an attorney to address, and so he can continue in his recovery. So in order to embrace his efforts for help, I have extended my hand to steer him in the right direction so he can pursue his recovery. I am, upon this board's approval, connecting him with sincere individuals like Ms. Byrne and Dr. Tilley, who are seasoned social workers and proven veterans in this community in their respective fields. So for these reasons, we all ask the board to accept his 6 months as time served and deny his revocation and grant him this supervision opportunity to heal. And I would like to thank y'all for y'all's time and consideration and your service to the state of Louisiana. And that's all I have to say.
Are you going to give him a place to live if he would be released?
Yes, sir, I would. And I think that was another part of his problem. He didn't have anywhere to go to. So yes, and have a place where he can come stay. He has an address to go to, and the parole officer can come check it out.
He was out of Oxford House for not paying. I didn't have the reason, but he said for not paying. How are you gonna work that out this time?
If
you said you talked to Oxford House and they would take him back.
I can also provide him with employment as well. Provide him with a job eventually, if how his treatment plan would let him start going to work. And I am going to help him with financial support. He has no mother and father. They're both passed away. He lost his mother at 22, and his father was at around 50 years old, I believe. So he's been roughing it out and struggling around, and he lost contact with me, and he doesn't really have any other family members. So I am prepared to help him financially, get on his feet and try to get him in a recovery track program.
Right. Thank you.
I will say it's not in my history or nature to reward someone from absconding. However, I believe when you have a mental health situation compounded by substance abuse, there needs to be some consideration. Our goal is public safety, and that can only be achieved through appropriate treatment plan. Mr. Barra, are you prepared to vote?
I'm ready to vote. All right. I think you got lucky with your uncle stepping back into your life. You need to take advantage of that when you do get out. But I'm not going to let you straight out to the street. What I'm going to do is I'm going to, in lieu of revocation, in other words, we're not going to revoke you, but order you to complete substance abuse and mental health with DOC. There won't be any charge on that. And then once you get completed with that, then you're going to go follow up and stay with your uncle and follow up with any aftercare that's needed at Oxford House and all those other places that he had. So we're going to start you off in a custodial treatment place where you won't have a choice about getting treatment or not. And that hopefully will get you moved right on into what all the stuff he's talking about.
Okay. Yes, sir.
That's my vote. I'm on.
Okay.
Mr. Childs.
I'm going to concur with Mr. Barra.
My vote is in lieu of revocation to send you to DOC substance abuse with follow-up with your uncle's outpatient plan. So Today, you have not been revoked outright, but you will be going to DOC custody for substance abuse.
Yes, ma'am.
Thank you very much. That
Yes, ma'am.
concludes
Thank
our
you.
there at East Veterans.
Alrighty, friends, with only a couple of minutes left and what I'm seeing in the courtrooms right now, more dragged out kind of hearings, I think we'll just go ahead and call it for this morning. We will, of course, be back tonight for Sidebar, 8 p.m. Eastern, 5 p.m. Pacific. This stream, when it ends, YouTube will send you over there so you can set a reminder. So do stick around to be able to set that reminder because we look forward to seeing you all tonight. I hope you had fun this morning. I did. Thank you, everybody, for your participation in the chat. Your kindness, your generosity, all of those things. It never goes unnoticed. The wisdom I leave you with today from Mary Holloway: resilience is knowing that you are the only one that has the power and the responsibility to pick yourself up. So consider those words. We will see you tonight, and then obviously we'll be back tomorrow for Super Friday, 9 a.m. Eastern, 6 a.m. Pacific. So look forward to seeing you all soon. Take care. God bless.